It's time for Friday Night Live. It is. There is so much to talk about tonight. Sorry for being late. I decided late that I was going to pour whiskey, and I was pulling up stories right until the end and even changed. Those of you that were here early might have seen me changing the title of the video as I was adding topics, literally frantically. And then I was trying to log into the text crew to text y'all. But as we are still resolving issues, it seems that I am completely locked out of my account until those issues are resolved. So isn't that a good time for all of us? Yep, it sure is. It sure is a good time to all of us. So it's good to see you. We've got a lot to talk about. Replay crew, love you. Let me tell you what is on the docket for tonight. We are going to do a weekly roundup of sorts. So it's going to be probably longer stories than our weekly roundup normally is. But we are going to be talking about the sentencing of Ghislaine Maxwell and R. Kelly. We are going to talk about the judgment in the Depp versus Heard case and the new news that has been coming out this afternoon that Johnny Depp has been ordered to pay the ACLU less than what they were looking for. I'm going off of news reports. I don't have those court documents yet, but I will pull them shortly. Pacer is down for bankruptcy courts. So we're going to be talking briefly about Erika Girardi's earrings and what happened there. And then we will be going over the Petito versus Laundrie ruling, what that means, et cetera, et cetera. So I'm going to roll the intro and then we're going to say hello and do things. Just a note, since I was live last Thursday, a lot has happened. I know there have been not just one large Supreme Court ruling, but numerous Supreme Court rulings. I have not had a chance to read them. I was traveling for a funeral and have just not had time to go through them at all. I am not covering it tonight. I will likely not cover it in a live stream. I generally do not cover the Supreme Court much. We have a lot of cases we've been following up on. When I cover the Supreme Court's latest rulings, I will be doing it from a breaking down the ruling and like the nuts and bolts and facts of that, and that is it. I'm not going to be debating it. I am going to be going through the nuts and bolts and kind of the what comes next, what rights the Constitution guarantees, how the underlying rulings happened, and all of that. So we're going to cover it in that way because, again, it's outside of what I generally cover, but the courts are not outside of what I cover. So it will be a very fact-based, this is how the court ruled, this is why the court ruled that way, this is what comes next, and that is it. Tonight, we are covering everything else, just absolutely everything else. So that is what we're doing. So thank you for knowing that we are moving past that, and that is why I am not addressing it tonight. We are going to be covering so many other things. So with the Supremes, I know a lot of people have covered it. I know a lot of the law nerds are like, but we want you to break it down. It will just be broken down in a very fact-based way. That is the way. When we just do the law things, that is it. So with all that said, thank you very much for being here, for being on this journey, and for understanding why we are covering other things. Again, this is a pop culture channel. I cover the law as it relates to pop culture cases. That is what I like to cover the most. But I also understand that a lot of you trust my opinion and trust the way I break things down with facts. And I really find that facts help, especially when there's a lot of fear. So I also feel torn between there's a lot of fear here and there can be facts, but also then there's this outside of what I cover, but also legally related. And so, with all of those caveats and a very fun glass of whiskey, I love these particular glasses because the ice freezes in like a triangle. So this is all ice and this is all whiskey. Emily, that's a very look, it's deceptive because this is all ice. So it is a fabulous and fun little glass. It's going to tip. It's going to tip. It's just going to tip. So with that, we're just going to tip it into my mouth, and it is time to roll the intro and get into all of the things we have to talk about tonight and do a little catch up because other things have been going on around the internet that I would like to say something about, even though they're going to make me sad. So let's just do it. Let's just get into
Hey there.
all the shit.
If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
I'm going to have to change the intro to take the news out of it. We used to do more news, and now it's just the pop culture. The law and the pop culture. We've got a whole ponytail situation going here. The pony has gotten so long, like we don't know what to do with her. Old Smoky, which is a Tennessee whiskey, Old Smoky salted watermelon whiskey. It is delicious, but this is kind of oh gosh, I'm going to get sad talking about this. And that's why we're going to talk about it early and then move on. When I thought about wanting to mention something about the passing of Technoblade, and especially coming off of the heels of just being at a funeral myself, it was, when I'm like, okay, blood for the blood god, I'm like, for me, that feels like a whiskey offering. For those of you that don't know what I'm talking about, there is a creator on the channel, I believe, if not at 11 million subscribers, just about 11 million subscribers. And I'm getting some breaking up notifications. Let me see if I can fix that real quick. But it shouldn't be, but I will see if I can fix that real quick. With that, Technoblade is a incredible creator on this platform, who passed during his battle with cancer. 23 years old, a huge part of a lot of lives of a lot of us and a lot of those who watch content on the platform. And I watch content across all different types of YouTube content. I love YouTube. And when I talked about this, and I talk about this on occasion, part of the reason I started on YouTube is because I really do love this platform. I love other creators. I love having conversations with other creators. I love this platform. I love watching all kinds of content. And my children introduced me to new creators who I might never find, but I've enjoyed, like back in the day, like Captain Sparkle's Minecraft content, and enjoyed Technoblade's content, and enjoyed Technoblade as a creator very much, as my kids did. Love the community that he had created on his channel. And we've seen that on social media in the last day, not even a day, since his family put out a video with a statement by him that he wrote shortly before he passed. And it's just, A, it's always heartbreaking losing people to cancer. B, it's heartbreaking losing people young. And C, Technoblade is a massive part of so many people's lives. I remember when he made a video announcing that he had cancer and had been diagnosed with cancer, and my youngest being like, oh, what does that mean? And we're like, we don't know what it means, but we know he's got a fight ahead of him. So very, very sad to lose. Look, y'all, I told you it was going to make me emotional. Very sad to lose a content creator on this platform who brought so much light. So this is why I talk about things on sometimes text, because it's just easier. It's just easier for me. But my kids and I had a great conversation today about Technoblade about Technoblade's content and about what that means when you're connected to a creator whose content you love, because truly Technoblade never dies because the content will always be there. So as I move on, blood for the blood god. This is why I don't talk about things. So it's just way too young and a life well lived. And I think a life well lived in this case can be measured by the joy that was brought to so many and to this platform, and how many will continue to cherish the content that was brought. So I still have Kleenexes in my office because I always need Kleenexes in my office. But so just knowing not only that content touched me, but also touched my kids, it's really nice to have, content creators that you feel close to in that way. So watching that, I think, is probably a little bit different. From my kids, they lost a content creator that they absolutely love, whose content they look forward to all the time. And as a parent who's also a content creator who loves consuming content and watched Technoblade's content as well, watching his dad put together such beautiful tribute was tremendously touching. And I can't imagine how difficult that would have been. And his parents handled that beautifully. His parents put out a wonderful video with a statement from Technoblade to his audience, and it was just such a touching tribute, and something that I think no parent can ever imagine going through. So for all of those struggling, cancer is just such a bitch, and it just kind of knows no bounds, right? So with that, I wanted to address it tonight. I try so hard. I try so hard to not be in mess. But again, Technoblade never dies. And to all of the content creators who were inspired, I think that's the legacy that a content creator leaves, is all the content creators that come, all of the content creators that come from watching a content creator like Technoblade and saying, I want to do this too, because I want to be part of this community that you're a part of, because you've made a community that's so beautiful and so welcoming and so fun. And that really is the legacy that someone leaves, a positive legacy of those that are inspired and the content that lives on. So with that, I know it was hard on my kiddos. I'm sure it's been hard on a lot of you and your family members as well. But I was talking about this on Twitter a little bit with Lauren today in the thread where I talked about Technoblade Passing. And it's been really, though, heartbreaking, beautiful to see the community sharing fan art, sharing memories, and sharing how inspired that they've been because of Technoblade. And with that, it really is a really inspiring thing to see how positive these communities can be. And I will talk mad shit on social media all day long. I will talk about how there are toxic corners of the internet, but there are also incredible communities and incredible connections to be had. And that is why I love being a creator on this platform. It's why, despite despite, the difficulties that come with being an online creator, I love it. And I love this platform. And it's seeing communities like ours and others that create a very compassionate and connected space. And I think that talks so much about not just individual creators, but the types of communities that are drawn to positive creators. And that is just a beautiful, beautiful thing. So a great legacy made by an incredible creator who was taken too soon. So, all right. And with that, we're going to move on. We're going to move on. We're going to move on. So, even the title of his video was cheeky. The So Long Nerds was it was just appropriate. So, with that, Technoblade will be missed, but Technoblade never dies. So, to all the parents who had to have difficult conversations with their little ones, also a difficult thing. All right. So, yay. It is, losing creators is something that we are relatively new at dealing with, because it's the internet and social media in the way that it is, like, this is new, and it still is fairly new, and it's still something that we're parsing how to deal with, and the connectedness you feel is different than a traditional celebrity or a musician that you love. It's just a different way that your creators, and it's just a different look at their lives, their thoughts, especially when you stream, and when you see creators interact with other creators. It just creates a different level of knowing someone. It feels like a different level of knowing someone, and that's a really special thing. And that is just, Allie, see, that's exactly what it is. If you're watching this, I'm dead. And his parents handled a thank you to the community with so much love. And that is really something that is incredible to see. A creator that truly loved his community. His family knew how much he loved his community, and he wanted to make sure that he said goodbye. And that was just, it's heartfelt. It's just heartfelt. So, and inspirational. We're going to just drink whiskey tonight. I've lost too many people to cancer in my life, and it feels like sometimes grief just amplifies, and amplifies and amplifies and amplifies. So with that, just, if you want to continue to support Technoblade's channel, I know that he, in his final statement that was put out yesterday, said that his siblings would be taken care of going forward with his channel. And his family has set up through his merch shop that, I don't remember what percentage it even said, but that a percentage of his merch shop will still go to sarcoma funds. And it's just, wow. It's just a lot. It's just a lot. But if you never watched Technoblade, you can still support his family and the channel, because again, the content, the legacy, and the videos live on. So to a creator that I was inspired by but never met, who inspired my children as well, they have a memorial t-shirt Tiffany shared. I'm sure that they do. I hadn't even looked. But I love that. I love that. I love that his legacy will be able to live on. And I think that's a really special thing. So Technoblade wanted to sell merch so he could pay for his siblings' higher education. And that's what was made very, very clear in his final kind of farewell to his community. It's just, it's heartbreaking. I was heartbroken yesterday when my oldest told us that he had passed, because they got the YouTube alerts while we were at a concert. And so I didn't have the opportunity to brace my very, very compassionate, very, very empathetic 10-year-old for that. So that when we got home from the concert last night, we got home to a very sad little guy. And I was looking at my oldest being like, dude, this, he's like, I didn't know. I saw the alert. I was excited for a new Technoblade video and was not aware that it was going to be a statement of farewell, that he had passed. And with that, we did go to a concert last night. It was a really nice time. So many of you shared. I had no idea that Bret Michaels had been hospitalized, so we missed Poison performing last night, which made me really also a bit sad, but one understands. So we saw Joan Jett and Motley Crue and Def Leppard last night. It was a lovely concert. It has been a very whirlwind since we left last Friday. The week has just been non-stop. And we knew it was going to be non-stop, but it was a lot. It's been a lot. It's been busy. I'm exhausted, but I am bummed that we missed Poison, and I hope that Bret Michaels returns to the road soon. I know that he is hospitalized here in Nashville, and I haven't seen that he has been released yet. So hopefully he will be released soon. So if you can catch the stadium tour, catch the stadium tour. It really was a lot of fun. Really, really was a lot of fun. So what else? There were other things I needed to say. I didn't mean to go on and on about Technoblade. I am sorry. It just needed, I wanted it to be said, because it just, it matters to so many of us. With that, I know for all of our Canadian audience, you are celebrating Canada Day. So happy Canada Day. For the US audience, you guys are getting ready. Us guys, us all, y'all, us all are getting ready for 4th of July weekend. It's probably going to be a weird one for a lot of people. And that's what it is. Our country has its ups and downs. But we keep going, which is why we have kind of the longest running Constitution, because we just keep running. I see the notes about Mike Static. I am working on it. It's an issue going. The issues I have been having with the tech, from the text crew to the StreamYard, the issues. The issues have been a challenge, but that is a StreamYard issue. So I see some of you in the chat that are like, don't feel very independent this year. We are going to, it's okay to just be like, damn the man. But we don't give up. We fight. And we can still be rebellious against our government. It's okay. That's how we started. It's in our blood. So let us move on to stories. Should we talk about people going to prison? Because that's what's up first. We're going to talk about R. Kelly going to prison first, and then we'll talk about Ghislaine Maxwell going to prison. And then we're going to talk about the Depp v. Heard case, where people want someone to go to prison and no one's going to go to prison. And then earrings, and then Petito Laundrie case, another case where people want people to go to prison and no one's going to go to prison. So, second oldest constitution. I tried. I truly, off the top of my head, do not know what the first one is. And I saw, what's more American than complaining about America? It's very fair. And I feel like it's super fitting to feel rebellious on Independence Day. It is fitting to feel rebellious and be like, look, it's time to remind the government that they are for the people, by the people, and of the people. It is okay. It is okay to remind your elected officials that they are of the people. And that is a fair thing. All right. Let us move in to our weekly roundup. That's not going to be so much of a roundup because it's going to be a little bit long, but it's still a roundup because we're rounding up the week. Did y'all follow the R. Kelly case? Some, much, not at all. Any of the above are okay. It's totally fine. Any of the above are okay. Any of the above are okay. R. Kelly went to trial, was convicted of 9 counts, including RICO racketeering, including coercion and enticement of a minor. These are going to be some of the same charges that we see in the Ghislaine Maxwell case. So we're going to just go ahead and take a look at this. Here's the thing. R. Kelly's not done. There are still pending trials for R. Kelly that are going to happen. So R. Kelly has been convicted, coercion and enticement of a minor, coercion and enticement of Jane Doe 5, coercion of a minor related to Jane Doe 5, transportation of a minor related to Jane Doe 5, transportation related to Jane Doe 6, coercion of and enticement of Jane Doe 6, transportation of Jane Doe 6, and coercion and enticement of Jane Doe 6. I'm not going to get into the specifics of those counts because A, I've done it in other content a bit, and B, I don't know if it's helpful as we talk about sentencing. So again, 9 counts that he was convicted of. I don't know if they list the mandatory sentence or the maximum potential sentence in here. I don't know if they added it all up. If you want me to go through the sentencing arguments the way we did with Josh Duggar for either R. Kelly or for Ghislaine Maxwell, let me know. We're going to go over the sentencing today, but if you want me to go through the arguments on both sides or go through, there are some, I think, submitted victim impact statements for Maxwell, we can go through those. We're going to do those in separate content because they can be very, very triggering. So let's go ahead and share the screen and just go over the sentencing documents. Oh, my nose is red and puffy. Look, man, I do not cry cute. I do not at all. I do not. You will always see my nose get red first, and then my cheeks, and my eyes get puffy. Always a mess. It's always just a freaking mess. Who is it? Do you know that R. Kelly's The Closet episodes got removed from YouTube? I had no idea that they had gotten removed. So let's go through this sentencing memorandum for R. Kelly real quick. Let's see. Found guilty on counts 1 through 9. Oh, I forgot counts 1 and 2. Counts 1, racketeering, and count 2, transportation of Jane Doe 5. These are the rest of the counts 3 through 9, which we talked about a bit. The defendant hereby committed to the custody, the Federal Bureau of Prisons, which is the Federal Bureau of Prisons, not state, but federal. 360 months, so 30 years on count 1, which I believe is the maximum on racketeering. So they maxed out, and I believe this is the maximum on racketeering. So they maxed out count 1 and then added all the other sentencing behind it. So 360 months on count 1, 10 years on counts 2, 6, and 8, 20 years on counts 3, 4, 5, 7, and 9, all to run concurrently. Here's what that means. Concurrently means they all run at the same time. So they've sentenced him to a bunch of stuff and it all runs at the same time. And they have sentenced him on every single count. Why would they do that? Well, if there is an appeal and one of the counts gets yeeted on appeal, then they just default to sentencing on the other counts. So that's why you see them sentenced on all of them. Also, my internet's being funky, so give me 1 second and see if I can force it to switch over. If I can't, I'll be back. But see, if I disappear, it will be brief. I'm going to try to force it to switch over. It seems like it's pulling Wi-Fi and not the landline. So give me 1 second, and that's because I was traveling with my laptop. I think I'm back. Yay! So that should be better. It should cut down on all of the buffering. So let's pull this back up. Thank you for your patience. Somebody, I saw you in the chat saying Emily needs to learn how to Amber Heard cry. I do. I need to learn how to cry without getting red and puffy. I do, because I can't do it. I'm bad at it. Even when, I mean, there were times in court during victim impact statements and stuff that I could not well hold it together and got yelled at for it, which is why when you're like, Emily, stop apologizing for having emotions. I'm like, I'm sorry. I'm trying to undo the scars that have been created by getting yelled at for having emotion, like visible emotion. But even when I would try to not actually cry, like doing all the things to try to hold in crying, my face would still get puffy. It still would get just mess. All right, let's look at the rest of what is in this sentencing document. Upon release from imprisonment, you will be supervised release for a term of 5 years. So after 30 years, getting released, it will probably be less than that. Why will it be less than that? There will be time served and things like that. So there will always be time where you don't do day for day for 30 years. And so 5 years of supervised release. What's interesting is how much supervised release they gave Josh Duggar. Like, Josh Duggar got a fuck ton of supervised release, like a surprisingly large amount of supervised release. This is only 5 years of supervised release. Let's see what that's going to entail. And we're going to just. Mandatory conditions. You must not commit another federal, state, or local crime, unlawfully possess a controlled substance, refrain from any unlawful use of a controlled substance. You must submit to 1 drug test within 15 days of release from imprisonment and 2 periodic drug tests thereafter as determined by the court. You must cooperate in collection of DNA as directed by the probation officer. Kind of standard. Not required to comply with the registrations of sex offender registration, which is interesting on the charges, but the coercion charges and the racketeering charges don't require that, so the judge is not ordering it. I found that to be interesting. Standard conditions of supervision. So these are all these literally when they say standard, these are the standards. This is how you report to the probation office. This is what you have to do with probation. You have to, tell them where you live, tell them all the things. And then are there any other special conditions? That's what we're looking for. Special conditions of supervision. Shall comply with any applicable state or federal sex offender registration requirements as instructed by probation. So they did not ticket up here for the Registration and Notification Act, but they did require it under the special conditions. So it's interesting to me why they did it that way. And why they said shall comply with applicable state or federal sex offender registration requirements as instructed by probation. So is it up to probation? Or any state offender registration agency? Okay, so wherever he lives, he may be required to register. It's just interesting that they did it that way. The defendant shall participate in mental health treatment program, which may include participation in a treatment program for sexual disorders as approved by the U.S. Probation Department. I've seen a lot of reporting saying that was required. It says may. It does not say shall. When you look at the law, when you look at the legal things, may means may, might, permissive, could, might, could. Shall means fucking do it. Shall means none shall pass is what shall means. May means whatevs. So this says may. I saw a lot of people talking about the fact that he is going to be required to participate in a mental health treatment program for sexual disorders. That's not what this says. Like, it's just not what it says. Defendant shall participate in a mental health treatment program. Shall participate. Some sort of a look. Shall participate in mental health. Great. I think all of us shall participate in mental health treatment. I do. Emily, do you have an aside? Yes. We live in a difficult world. We live in difficult and changing times. Things are hard. Things are stressful. Things are scary. Things are out of our control. Things are fucking wild. For those of us in my age range, we are raising kids in a world that we did not grow up in, and it is hard to do. Mental health support is great. It's great. It's needed. We need it. Do that. So, shall participate in a mental health treatment program, which may include, not must, not shall, may. It may. You're allowed to do that if you want to do that. As approved by the U.S. Probation Department, defendant shall contribute to the cost of such services rendered. You have to pay it. That's not true for every defendant. Not all defendants have to pay for their own mental health treatment program. A lot of those that are in custody will receive mental health support needed, should happen. But he is going to have to contribute to paying for that, which is a good thing. Has the money to do so. The defendant shall disclose all financial information and documents to the probation department and assess the ability to pay. As part of the treatment program for sexual disorders, the defendant shall participate in polygraph examinations and or visual response testing to obtain information necessary for risk management and correctional treatment. That's where the shall comes in, which is very, very specifically tailored to this defendant. As part of the treatment, which is interesting because it says may up here, and then it says as part of the treatment down here, participate in polygraph examinations, lie detectors, and or visual response testing to obtain information necessary for risk management. Interesting. Defendant shall, don't fucking do it, shall not associate or have any contact with convicted sex offenders unless in a therapeutic setting and with permission of the probation department, shall not associate with children under the age of 18 unless a responsible adult is present and he has prior approval from probation. Prior approval does not apply to contacts which are not known in advance by the defendant, where children are accompanied by a parent or guardian, or for the incidental contacts in a public setting, like if you're at a restaurant or something. Any such non-pre-approved contacts with children must be reported to the probation department as soon as practicable, but no later than 12 hours. Upon commencing supervision, the defendant shall provide to the probation department the identity and contact information regarding any family members or friends with children under the age of 18 with whom the defendant expects to have routine contact, so that the parents and guardians of these children may be contacted by the probation department and can approve routine family and social interactions, such as holidays and other family gatherings. If the defendant cohabitates with an individual who has minor children, the defendant will inform that other party of his prior criminal history concerning his sex offense. Moreover, he will notify the party of his probation or prohibition of associating with any children under the age of 18 unless a responsible adult is present. So they are going to try to monitor everything he does and all of the contacts or potential contacts with children. Shall report to the probation department any and all electronic service accounts. Try that again, Emily. Any electronic communications service accounts. So that's going to be all email accounts, social media accounts, cloud storage accounts. Defendant shall provide for each account identifier and password and shall report the creation of new accounts. Why? Because probation doesn't want him sliding into the DMs of anybody. Because DMs it's not a place to chat with children. Don't get into the DMs. So the defendant has to provide the user account ID and password. Yikes. The user account ID and password to any and all email and social media accounts so they can try to monitor any contact that Duggar may have. Duggar. Damn it. R. Kelly may have that way. The reason we don't see some of these prohibitions on Duggar is because his charges and convictions were different. And the cases were different. That's not what I meant to do. I meant to do it this way. Shall submit person, property, house, residence, vehicles, all your shit, literally all your shit to search and seizure, to search, not seizure, search. Search and seizure goes together in the law. I'm not going to explain in my brain why they end up together. So all your shit is subject to search, all by probation at any time, like anything. Failure to submit to a search may be grounds for revocation of release, meaning you can go back to prison. The defendant shall warn other occupants of the premises that may be subject to searches and seizures. If somebody lives with him, they have to know your shit's going to get searched at any time, or could get searched at any time. Defendant is not to use a computer, internet-capable device, or similar electronic devices to access any visual depiction as defined by 18 U.S.C. 2256. That means all of the explicity ones, including any photograph, film, video, picture, computer, or computer-generated image or picture, whether made or produced by electronic, mechanical, or other means of sexually explicit conduct. The defendant shall not use a computer. No porn. The defendant shall not use a computer, internet-capable device, etc., for viewing naked images of those under the age of 18, though it says it very specifically. Emily, are you worried that those two words together is going to make YouTube go crazy? Yes. The defendant shall not use his computer to view sexually explicit conduct or visual depictions of naked minors stored on related computer media, CDs, DVDs, any of the other things. So this is going all through a prohibition on any illicit images, particularly of children, but also of not children. So it says any sexually explicit conduct. Defendant shall refrain from contacting the victims of the offense. This means he shall not attempt to meet in person, communicate by letter, phone, email, internet, third party, without the knowledge or permission of probation. Upon request, defendant shall provide probation a full disclosure of financial records, including commingled income, that goes through the financial, shall comply with all possible restitution orders, pay your restitution. Total assessments, $900, total fine, $100,000, JVTA assessment, $40,000. The determination of restitution is deferred until 9/28/2022. Not done yet. Restitution to the victims is going to be determined later. So if he has a restitution order, that will be determined in September. And these are the other fees and fines. So, Karen Rose, why are you repeating everything 47 times? Because that's how it's written in the order. It is. All of the things. These are how the legal document's written. Every single sentence is written out. Every single time. I'm confused. Isn't he going to be in jail? Yes, he's going to be in prison for less than 30 years, but 30 years. He will be in prison. But this is what happens when he gets out of prison. So these are all the things that are going to happen when and if, when. I mean, he's not old in the way where I would look at 30 years and be like, I don't know. I don't think that's going to happen. He is not of an age where I would think he might never get out. I mean, he might not. Prison can be very difficult and dangerous. But with 30 years, given his age, he'll be old. I think he's 57. Let me just 55. All right. So, I mean, people live well into their 80s and 90s. So 30 years for R. Kelly. This, though, can go up because he has other trials that are pending. So other pending trials. Libby might be off topic. Why is Cosby out of prison? I did a episode about that and talked about his appeal. So that's been done. So R. Kelly, if he is convicted in other jurisdictions, because he still has pending cases, that time will get tacked on after this time. So it's very possible that with this 30 years, if he gets convicted elsewhere and gets 30 years, this, that, then he could end up in for longer. I don't know why my lights changed color. They were supposed to be pink. Have they been not pink this whole time? When did they change color? I didn't notice. Why? Because I'm exhausted and upset. That's why. Shall we move on to talk about Ghislaine Maxwell's sentencing? Sure. More people going to prison for doing awful things to minors. Every time I talk about this case, YouTube immediately goes, "You shall not discuss this case." Interesting. Same thing doesn't happen with R. Kelly. But when you talk about Ghislaine Maxwell and her associate Epstein, every single time it happens. I've broken down the Maxwell case in other content, but she was convicted of being the facilitator for Epstein. And that she has been sentenced. There are still going to be appeals pending. I don't think we will ever see anyone in Epstein's Rolodex arrested or prosecuted. I think this is probably going to be the end of it. So that is what that is. But for Ghislaine, she is going to prison. So let's talk about her sentencing. I saw the statement she released. I'm going to have to pull it up. So let's see. Found guilty on counts 1, 3, 4, 5, 6. Judgment not entered on 1 and 5 as multiplicitous, meaning they are in the alternative. Docket number 657. And then, so the court is entering judgment on counts 3, 4, and 6. 1 and 5 are not having judgments entered. And then it was not guilty on count 2. So count 3, conspiracy to transport minors with intent to engage in criminal activity. Count 4, transportation of a minor with intent to engage in criminal activity. Sex trafficking of a minor is count 6. The defendant has been found not guilty on count 2, 7, and 8, and the underlying indictments are dismissed. The underlying indictments, 7 and 8 were hung, I believe, if I'm remembering correctly. And those were dismissed. They're not going to retry them. That makes sense. Let's get into Ghislaine's sentencing. The defendant is sentenced to a term of 240 months, so 20 years. Count 3 has a sentence of 60 months. Count 4, a sentence of 120 months. Count 6, a sentence of 240 months. All counts to run concurrently at the same time. The court makes the following recommendations to the Bureau of Prisons. Defendants to be considered for designation to FCI Danbury. That's a location. Defendant is to be considered for enrollment into the FIT program. I do not even remember what federal FIT program stands for, but these would have been recommendations the defense attorneys would have asked. She is still going to appeal. Defendant was notified of her right to appeal. That is going to happen. 3 years on counts 3 and 4, 5 years on count 6 to run concurrently. Mandatory conditions. Let's see, where is the term of, oh, here it is. Upon release from imprisonment, you will be supervised for release on a term of 3 years on counts 3 and 4, 5 years on count 6. So 5 years supervised release. After the 20 years, again, it will be less than 20 years based on early release. Mandatory conditions. These are going to be the same. Must not commit another federal, state, local crime, possess controlled substance, use controlled substance, must make restitution, must cooperate with DNA collection, must comply with the requirements of the sex offender registration. Again, I'm surprised they didn't just tick it off on item number 6 in R. Kelly's case. I'm surprised they put it under the special orders. Truly. Standard conditions are the same. This is work, report to probation, tell them where you live, stay in touch, do all the things. Special conditions. These are the more interesting ones to me always. My ice cube has now broken off from its glass and has just formed itself into a nice little cube. But the glass looks so pretty when it starts. All right, let's make this bigger. You shall submit your person, property, residence, vehicle, paper, computer, other electronic communication, data storage devices, cloud storage, or media, all your shit to search. The search is to be conducted when there is reasonable suspicion concerning violation of a condition of supervision or unlawful conduct. Failure to submit to a search may be grounds for revocation of release. You can go back to custody. You shall warn any other occupants that the premises may be subject to searches pursuant to this condition. You must undergo a sex offense specific evaluation and participate in an outpatient sexual offender treatment and or outpatient mental health treatment approved by probation office. You shall abide by all rules, requirements, and conditions of sex offender treatment, including submissions to polygraph testing and refraining from accessing websites, chat rooms, instant messaging. I love that they still have chat rooms in there. Where do chat rooms still live? Social networking sites, to the extent that the sex offender treatment and mental health program determines that such access would be detrimental to your ongoing treatment. You shall not view, access, possess, download any PORN involving adults. Emily, did we already say porn earlier? Yes, we did. Any adult pornography, unless approved by the treatment provider. That'd be an odd conversation to have. You must waive your right of confidentiality in any reports because they need to be turned over to probation. You must contribute to the cost. We'll evaluate your ability to pay. The court authorizes release of the evaluations and reports. You must not have any contact with the victims of this case. Additionally, you must not directly cause or encourage anyone else to have contact with the victim or victims in this case. You must not deliberately have contact with any child under 18 years of age unless approved by the U.S. Probation Office. Must not loiter within 100 feet of places frequented by children under the age of 18, such as schoolyards, playgrounds, arcades, Twitter, Instagram, YouTube, and all of the internet. I love that arcades is in there, though. It feels so quaint. Even though we're talking about really awful, dark, horrible subjects, arcades sounds so quaint. Why would they say adult PRN? Well, they distinguish in some of these cases, especially when there's prohibitions around minors. They generally include the information they included in R. Kelly about pornography involving the underage, which again is child sexual abuse images. But here they really do say any pornography, and then they clarify regarding adults. Why do they clarify regarding adults? Because they want to make sure that they know that that's not okay either, unless it is approved by the treatment provider. So no contact. We got to arcades, and then I wandered from arcades. I miss arcades. I mean, the GameStop buses or whatever are just not the same as arcades. It's just not the same. You must not view or access any web profile of users under the age of 18. Don't go trolling the Snapchats for minors on the Snapchats or the Instagrams. This includes, but is not limited to, social networking websites, community portals, chat rooms, and other online environment, audio, visual, or messaging, which allows real-time interaction with users without prior approval. Don't be in the chat. Oh my God, Panda Purr said there's an arcade bar in my city. The thing I didn't know I needed but want desperately now. I mean, not like a Dave & Buster's one either, because they're way too loud for me. Like, not that. Like a very chill adult arcade bar where I could go play old school arcade games would be so much fun. All right, we got to deliberate contact, provide probation with access to requested financial information. You must not incur new credit charges or open additional lines of credit without approval. Let's see. Assessment $300, fine $750,000. It's a lot. And it looks like, when are they going to do restitution? It doesn't say. I'll have to go look back and see when they're going to do restitution, because it just has the fine here, but it did say payment of restitution, but they might not do restitution. They might not do restitution because of the earlier victim settlement fund. Let's see. So I don't see anything noting it, but I'll go look. So I'll go look for that we're trying to do these in a quick bits, weekly roundup. So we're trying to move along. All right. You know what? I'm going to move topics around. We're going to do Erika Girardi's earrings next. And then we're going to go to Depp v. Heard stuff, because there's multiple stuffs there. Emily. Oh no, I should probably do that last. Well, no, we won't. We'll just deal with inebriated discussion of the Petito Laundrie ruling. It will be fine. And then we'll move to questions. It'll all be fine. It will all be fine. Question: in 30 years, won't technology be so beyond what the conditions are? That's part of the problem, that they try to make these broad enough that it will encompass for the future. And they try to say, and that's why you get this weird language of like, any way this works, or any place where you can have real-time interaction. They really try to future-proof it, but it's very hard to do. Because if the past is any indication of the future, we have no idea what technology will actually look like 30 years from now. I hope to live to see it, but we have no idea what it will be like. And then our kids will be navigating a world that they did not grow up in. All right. So let us continue on. We're going to just do Erika Girardi's earrings real quick, because, at least it's not people preying on children. So there's that. If you've watched my content on the Girardi case, you know that we are woefully overdue for a Girardi roundup, because a lot has happened. But we talked about the earrings. Hold on, I need a picture. Emily, did you pull this up in advance? No. These are the suspected earrings. These are, let's see. These are the suspected earrings that we were talking about. Let's see. People think so too, because People has used this picture with their article on this. If you want to know about this motion, I covered it in other content. These earrings outraged me. When I went through the filing from the bankruptcy trustee, Emily, back up 1 second. Your brain is moving in whiskey time. Tom Girardi, Erika Girardi's estranged husband, now under a conservatorship, famous lawyer in Los Angeles, is alleged, in some instances alleged, and in some instances it's just been proven at this point, to have taken client funds improperly. The level of that impropriety is still unraveling. The tip of the iceberg happened in 2020, and we are slowly working our way down the iceberg to find all the shit that lays beneath. But caught in that has been Erika Girardi, who has clearly benefited from the money Tom has siphoned off of his clients into their personal lifestyle. Caught in that was this pair of earrings purchased ages ago for $750,000. $750,000. The bankruptcy trustee is estimating they are now worth well over $1 million. So these earrings were paid for directly out of a client trust account. Emily, you can't just pay for shit out of a client trust account. I know that. And so does the judge, which is why these motions started months ago. The bankruptcy trustee asked for the earrings to be turned over because they are funds that should be in the law firm. There are two bankruptcies here, one for the law firm, one for the individual. The individual bankruptcy is still trying to sell the house in Pasadena and all that stuff. The law firm bankruptcy is trying to claw back any assets that they can to then sell and then pay back into the law firm to pay back all of the creditors, clients, attorney lending services, other lawyers, clients. So these earrings, these earrings that I don't even know how you would keep up on your ears because they look so damn big. Half the time on the show, these earrings were pulling her ear down like this. She wore them quite a lot last season. So these are supposed to be the $750,000 earrings. Erika was asked to turn them over to the trustee. Erika's attorney was like, fuck no, we're not turning them over. We don't know how you're tracing the funds, et cetera, et cetera. Look, Erika's attorney is doing his job in protecting her interests. You have to show us that you know, or that you can prove where these things came from, and then the court has to decide. I'm going to pull up more pictures of these earrings. Hold on. Let's see. They were at the reunion. They were at the scary dinner. They were at the or what dinner as well. So they were at the reunion. They were at the or what dinner, but they're these massive earrings. So the bankruptcy trustee said those got paid for from client funds. They're the property of the law firm. Erika's lawyer was like, nah, prove it. And the bankruptcy trustee's like, here's the receipts. I covered all that on the channel. There are multiple videos about all of those different parts of the motion. This came for hearing, and the judge ruled that the earrings must be turned over to the bankruptcy trustee. The bankruptcy trustee has been holding on to them, but the court ruled on the 28th. I don't even remember what day that is because I think today is July 1st. So a few days ago, the court ordered that the earrings had to be turned over to the trustee, and the trustee gets to now auction them, sell them, however they get rid of them, and that the money garnered from them, whether be it $750,000, be it $1.2 million, be it whatever it is, those funds go back into the law firm as assets to pay out to the creditors that are owed the money. So that is the job of the bankruptcy trustee, to try to find all the assets, turn them over. So this comes to us from Law 360. Again, the bankruptcy court side of Pacer was down today. So when I went to pull this up, I should have done it yesterday. But yesterday, look, the ticketed time for the concert yesterday was like 4:30. Here I'm thinking, 7:30, it'll be great. And I look at the tickets, I'm like, fuck, Dr. B, it says 4:30. We have to go. So I didn't get to do it yesterday. This comes to us from Gina Kim over at Law 360. Girardi ordered to turn over pricey diamond earrings. Pricey's an understatement. Reality television star Erika Girardi must turn over to a bankruptcy trustee. Well, technically they already have them. They were being held in trust, but now actual legal possession of them are being turned over. A pair of diamond earrings that her estranged husband, the disbarred attorney, I love that. They're like, he is now officially disbarred everywhere. So we're going to just put that in. Go Law 360. The disbarred attorney, Thomas Girardi, bought in 2007 for $750,000. The Los Angeles bankruptcy judge said Tuesday, finding that it was clear that stolen funds were used to buy them. Stolen funds. Here's how the funds got stolen. The money was in the client trust account, and Tom Girardi wrote himself a little checky poo out of the client trust account, labeled it as costs, and paid the jeweler for the earrings. What is supposed to happen is money goes into the client trust account, the attorney pays themselves their attorney's fees and costs, and then the rest of the money goes to the client. But the money gets moved and accounted for specifically to the penny. But no. Nay. Tom Girardi was just and just paid for it directly out of the client trust account with a check, the check that the bankruptcy trustee presented as receipts. U.S. bankruptcy judge Barry Russell said during oral arguments Tuesday that while he agrees that this is quote unquote an unfortunate case, the facts are nonetheless straightforward. Yes, there's a check. The check is the check. And the settlement funds from the trust account created for a class action handled by Tom Girardi's firm were used to pay for the diamond earrings in question. Yeah. The judge said it was clear to him that there had been a theft of those funds. Yup. But the judge noted he didn't believe that Erika Girardi, star of Bravo's Real Housewives, cast member? No, she's been kind of carrying the last season. Like the last season was carried by Erika. But I'm so far behind on this season. We'll talk Housewives later. Emily, can we talk about Housewives and questions? Yes, we'll get there. Finish this. All right, I got it. Star. Okay, cast member of Real Housewives of Beverly Hills. Fine, star. You can let me know. Star or cast member. Who is also known by her stage name, Erika Jane. I've lost the sentence. I've lost the point of the sentence in my wanderings. I apologize. The judge said it was clear that they were stolen funds, but noted that he didn't believe that Erika was aware the earrings were stolen property, but that nonetheless she was in possession of stolen property. Here is the thing. I have said this about this case a lot. A lot has come out that doesn't make Erika look good. Most of it she has done on social media herself. But none of it means she knew the level of fuckery that Tom was up to. And I have not yet seen anything, and I know it's an unpopular opinion. I have not seen anything yet that proves that Erika knew the level of fuckery that Tom was up to. I reserve the right to change my mind as new evidence comes in, but I have not seen anything yet where I'm like, we know she knew because of X fact. Speculation, behavior, but how would she not? It's like the American Express bills. Her husband is paying the American Express bills out of the law firm. How does she know what account he's paying those bills out of? It's like the bills are being paid. Okay. I don't know how she would know that they were being paid out of a law firm bank account and not his personal bank account. I just don't know how they prove that yet. But she was benefiting, and that's why they're clawing back property. So, let us continue. At the end of the day, the trustee is tasked with the duty to gather any and all assets of the now defunct firm and Emily, should you drink this much whiskey early in the stream? No. And disperse funds to Tom Girardi's former clients. Tuesday's hearing stems from a January motion filed by the trustee, who alleged that the embattled attorney paid for the diamond earrings. Well, she showed the receipts. So, the check was cut directly out of the account. Erika fought those accusations, contending that she never managed finances for the firm, denied knowing how the firm or Girardi handled the client trust accounts. Through their marriage, Erika Girardi said she believed her husband and the firm were financially successful, extremely wealthy, and made lots of money. Here's why I give her the benefit of the doubt to a lot of that. There were multiple billion-dollar-plus settlements, and he's taking 30 to 40%, if not more of that, plus costs. If somebody said to me, hey, you earned 30% of $1 billion, I'd be like, so money forever. Cool. And so it's hard for me to know yet what Erika knew. Benefited, yes. What she knew, don't know yet. Specifically, I had absolutely no involvement in or knowledge of the actions of Tom Girardi or Girardi Keese in connection with what I'm told was called the Ruslian litigation or the GK trust account in that litigation. Erika Girardi wrote in her declaration on June 14th. She further insisted that Tom, in the early 2000s, gifted her with what she said appeared to be expensive diamond earrings. Well, yes, it is expensive to be her. Erika Girardi further noted that the earrings were stolen during a home burglary, but that in 2007, Girardi gave her another set of earrings to replace the stolen set. They've had an interesting number of burglaries. I'm going to need somebody to investigate. I am not a journalist nor an investigative reporter, but I need somebody to tell me about all these burglaries because I wonder if insurance claims were made. I have questions. And if insurance claims were made, wouldn't the earrings have been insured? And if the earrings were insured, did they double dip by then taking the money out of the client trust account? Like The finances here are in such fuckery that some investigator for the IRS is got to be laughing somewhere going, like the evil IRS laugh. Because the level of fuckery, just the level of fuckery going on. But again, don't know what Erika knew about Tom's level of fuckery over at the law firm. I want to know, as Jay Edelson has asked, what the other attorneys knew. I want to know that. I want to know that. She added that she had no reason to doubt the source of money her husband used to buy the set. I don't disbelieve her. I don't like, L. Brahman said, remember the earrings were not insured. Who doesn't insure $750,000 earrings? Oh my God. We don't do things other than facts on this channel generally. But here's some fuckery that we're just going to indulge in for a moment. Give me a moment of fuckery, please. This is pure fuckery. I don't think they've appraised the earrings yet. I haven't seen anything that says that they've appraised the earrings. What if these earrings that have been turned over are not actually $750,000 diamond earrings? I want to know. Like, there's so much room for, like, my brain goes towards like money laundering shit. Like, what if? And I think we'll see it play out. I think Erika's going to be left holding a fucking crater of debt over this bankruptcy. But just what? Just what if? What if the earrings are long gone? Well, we'll see. The bankruptcy trustee has them now. They got to appraise them before they can sell them. And we'll see all of that information because we get to see when they get sold. Erika's declaration also said she received an income tax due notice bill from the state franchise tax board, that's California, last month, saying she owed just over $2.2 million in taxes for 2019. The star maintained she does not have the ability to pay that bill. That's $2.2 million in California state taxes. We haven't gotten to the feds yet. I'm telling you, the taxes are going to be the downfall. The bankruptcy's bad. The taxes are going to be the end. On Tuesday, Erika's attorney, Evan Borges, they didn't give him his middle. He's Evan C. Borges on all his filings. Look, don't leave out the middle initial, people. Said by the girl who heavily relies on a middle initial. We can't forget the D. Give Evan C. Borges his C. Anyway, Erika's attorney, Evan Borges, restated his argument from his opposition papers and contended that the trustee's claims are barred by the statute of limitations. It's a bankruptcy, Evan. In addition to the 7-year statute of repose in California, which he said applies to fraudulent transfers, Borges argued that Erika Girardi is being bombarded with accusations and lawsuits based on her husband's conduct. I agreed. And that the check signed by Thomas by Girardi and deceased partner James O'Callahan did not indicate theft. Borges added that the judge disagreed. Borges added that there was nearly $65 million, the settlement payment from that case. Megan, we're going to come back to this. It depends on your state, but yes, we're going to come back to that. I will get to that in questions. For our international audience that is like, what the fuck are y'all doing? Yeah, when we talk about our taxes, that's the appropriate response. Borges added that there was a nearly $65 million settlement payment from this mass tort action, and that the firm's partners paid themselves $2 million for purported costs. But as of the date that the $750,000 check was issued, the trust account was not in a negative balance. Well, it doesn't matter if it's a negative balance. You have to take the funds that you are entitled to out of the trust accounts and then put them in your accounts and then use them. You can't do them directly out of the trust account. If Girardi Keese at the time were hypothetically entitled to a contingency fee ranging between 33% and 40%, the firm would presumably have been entitled to $21 to $25.9 million in attorney's fees. Yes, So why write it out of the client trust account? If the firm were owed at least $20 million in fees as of March 2007 when the check was issued, nothing would have been taken from the clients. Borges also noticed a very suspicious payment to Jams for $500,000. Jams is a mediation firm or a mediation group that deals with arbitration and mediation. There was a very suspicious payment to Jams for $500,000 that said he had never heard of such a thing and also saw other payments made to co-counsel or at least described as such. Well, Borges said he wasn't defending the firm. He argued it's not a theft of client money if the firm had an entitlement to the funds that far exceeded the amount. So the argument from Erika Girardi's attorney is, look, if you are entitled to $20 million in fees, between 21 and 25 million in fees, it doesn't matter that you're taking $750,000 out of the client trust account. That's not client funds because you're entitled to 21 million in fees. The thing is, you have to take the money and put it in the other account. And that's why the judge said, I'm informed that Mr. Girardi has dementia. I have no idea if he does. Some probate judge apparently found that he did, and O'Callaghan is now deceased, Borges told Judge Russell. The evidentiary gaps are the reasons why lawmakers passed the statute of repose. My client takes this very seriously, Your Honor, Borges said. This is Erika's attorney. My client left this marriage to move into a rental, filed for divorce on her own, and all she took with her were personal possessions, which do include jewelry. But all she's got are those personal possessions plus her income from Real Housewives. It's funny how people sort of snicker about. It's funny for people to sort of snicker about, but it's all she's got as far as income. I don't doubt that she's in a gaping fucking hole because of what Tom Girardi did. I don't know where that snicker comment came from. I wonder if something was going on in court. Larry Gabriel, special litigation counsel for Miller. Remember, there's a new special litigation counsel after old special litigation counsel either quit and or was yeeted, depending on the reports you believe. Special litigation counsel countered that the Girardi Keese firm cannot take money out of a client trust account because you can't. However, the firm wrote the check for the earrings payable to M&M Jewelers and booked it as a cost. Right. The end. Buying the earrings with money was clearly fraudulent, is a theft of funds, Gabriel argued. The statute of repose does not apply. There's no blanket statute of repose for stealing trust funds and using them to buy earrings. She is in receipt of $750,000 out of a trust account that belongs to someone else, Gabriel argued. This case is a tragedy for everyone involved, and Thomas Girardi himself had a brilliant reputation and career, but there was something wrong, and the people who suffered are his own clients, Gabriel told the judge. At the end of the hearing, Judge Russell sided with the trustee and ruled the earrings will be sold in open court. Y'all start pulling your money together. Well, there's no final ruling on where the money will go. It would likely go to the estate and trustee. That's where it should go, because then it can be determined to go to which beneficiaries. Go to the estate and trustee to be turned over to beneficiaries and plaintiffs in the Resulin litigation, the judge said. That would assume that they have not been paid off in full. The next status conference in the case is set for September 27th. Counsel for the trustee did not respond to requests for comment. In a statement, Girardi's lawyer, Erika Jane's lawyer, said his client is facing consequences for past actions taken by Tom Girardi and Girardi Keese. Erika did nothing wrong. I wish the bankruptcy trustee would focus on the actual aider and abettors of Tom Girardi and Girardi Keese and stop pummeling his ex-wife. The problem is that his ex-wife likely has the bulk of the assets that can be sold, and that's why they are going after her, because she has the assets that can be sold. Borges further stated, legally, the judge's decision raises an issue of whether the law allows revisiting transactions 15 years ago to take away a gift by an innocent spouse. But that's for a higher court to decide, indicating that they will, in fact, appeal. This case is going to go on literally forever. This is the case that never ends. I see you guys in the comment section saying Sutton should buy the earrings. Can you imagine if another housewife purchased the earrings? Oh my God. I was reading, I messaged it to Warren. Hold on. Emily, are we just going completely far and afield? Yes. Give me 1 second as I go to my DMs and hopefully don't expose them on screen. You don't need to see who's DMing me. But I DM'd this to Warren. Hold on. Where is it? No. Wait. Which account did I send it to? The problem is Warren and I DM on, there we go. Multiple platforms. This is what I was looking for because this I think is hilarious. Facts. When the IRS auctioned off Willie Nelson's assets in 1991, fans bought his property and returned it to him. Quote, we try to work with taxpayers, the IRS spokesperson Valerie Thornton told the New York Times in the autumn of 1991. And if we have to come up with some creative payment plan, then that's what we're going to do because it's in everyone's best interest. The creative payment plan to which Thornton was referring to in her statement to the Times involved a unique revenue sharing agreement negotiated between the IRS and beloved country singer Willie Nelson, who was then struggling to repay a $16.7 million tax debt that had led the federal government to seize all of his assets 1 year earlier in 1990. Nelson landed himself in tax trouble as a result of investments he made in the early 1980s in a tax shelter later ruled illegal by the IRS, which is unfortunate when you think you're safe and then you're not. With interest and penalties on top of his original unpaid taxes, Nelson was facing a tax bill in excess of $16 million. And through his lawyers, convinced the IRS to accept $6 million cash payment to settle the debt. Even this was more than Nelson was able to pay, despite being perhaps the most bankable country music star of the day. He didn't have $1 million, probably didn't have 30,000. His daughter told Texas Monthly Magazine of her famously generous and free spending father. In anticipation of negotiations with the IRS breaking down, Willie Nelson had his daughter remove his beloved guitar trigger from his Texas home and ship it to him in Hawaii, where he was golfing when the feds raided his home on November 9th, 1990. As long as I got my guitar, Willie Nelson said, I'll be fine. And it seems that when they auctioned off the things that they seized, his fans bought his property and returned it to him. We will see if Erika Girardi's fans are of the same generous ilk, won't we? I had no idea about that story, but when I sent it to Warren, I was like, well, that's community. That's Willie Nelson's fans are like, fuck the IRS. We'll buy it and give it back to you. We're not letting your shit just be auctioned off. And when you put your money in an investment where you think it's legal and then it turns out not to be legal, I don't know what you can do with that. Chris CPA, thank you for the generous super chat. You didn't have to super chat that much to buy a hat. The hat says facts. It's been suggested from the law nerds that we need to embroider not fuckery on the back, like over where the snaps go. I'm going to look into that because I think we need a version 2.0. But it's from lawnerdshop.com. If you've never been to lawnerdshop.com, you're going to go to lawnerdshop.com and be like, Emily, is your Pride merch a month late? Yes. Is it still going up because we do it as a fundraiser? Also, yes, we can have Pride all year long. I know it's in June. It's just going to happen. Lawnerdshop.com. If you go to the different things, hats are down here. And this is the facts hat. It is very hard to see because it is black on black. And I will see what we can do to get it embroidered on the back as well, because I love that idea. But that is the facts hat from lawnerdshop.com. So thank you, Chris, not only for the generous super chat, but for the interlude to plug the merch. So I appreciate you. Thank you very much. All right. Michelle, I do respond to Facebook chats. I see them. We have like 15,000 people across platforms. So the chats do go fast. So I do see them. They actually stand out because they're in blue, but it just depends. All right. What are we doing next? We did Erika Girardi. We have Depp things, and then we're going to get to the Petito laundry stuff. So let us do the Depp things, and then we'll go to the Petito laundry things. We're on whiskey time this evening. So it's kind of like sweet tea time, but let us continue. I think Erika Girardi should pledge it for the earrings. I think we all should pledge it for the earrings. the earrings are going to have to be appraised, and that will all be in court documents, and that's the tea. When the earrings get appraised, that's the tea. Do I doubt they're real? No. But wouldn't that be fucking wild? Yes. So let's do, we're going to talk about Depp and Heard, and then we're going to go to the Petito, and then the Petito ruling in the motion to dismiss, and then we're going to go to questions. So let us go. We're going to do the Depp versus Heard judgment first, and then we're going to get to the ACLU and why Johnny Depp has to pay the ACLU. But the Depp versus Heard judgment is in. Of course it came in while yours truly was on a plane, but we knew that was going to happen on the 24th. What does that even mean? Well, the final entry of judgment was, in fact, entered. The entry of judgment is who has to pay what and who. So we're going to look at the judgment. You've probably already seen it by this point, but we're going to look at it together nonetheless to see the official entry of judgment. And then we are going to move on to Johnny Depp and the ACLU. If you guys want a more thorough breakdown of that case as I'm looking for this document, please just let me know and I will do that. So we also, we have other things too. We have an updated, corrected transcript filed by Heard's team. You guys, if you listen to this week's podcast episode already, go ahead and just pop a 1 in the chat if you listened to the podcast episode, because here's some tea. The transcript of that hearing is now available, and I feel like we need to go ahead and go over it. Not today, in another day. I have a few transcripts I want to go over, but we need to go over that transcript. So all of you are like, yes, 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 yes. Thank you to all of you. 3 in the chat. 3 is not a 1, Creed. Thank you to all of you who have listened to this last week's podcast where we talked about the UK case. Here's the thing. They've now filed the transcript from that hearing where they were arguing about the UK case with the court. So we now have like 100 pages of transcript. Don't we need to go over that? I feel like we should go over that. There's also a PowerPoint presentation that's been lodged with the court. We can go over both of them. So we can go over both. If you want me to go over them, we will go over them. So this is Elaine Bredehoff in this transcript at this hearing is like, and what I did something a little unusual, Your Honor. I prepared a PowerPoint, but I have it in a hard copy slide instead of actually doing a PowerPoint. Part of it was we didn't know what courtroom Your Honor would be in. We didn't know the electronic situation would be, so I ultimately decided this made more sense. So I made a PowerPoint. I brought a copy for everybody. But it's not a PowerPoint. It's a printout of the PowerPoint. The court said that's fine. So with that, if Your Honor is ready. Okay, yes, sir. Yes, ma'am. Go ahead. Thank you. Mr. Depp's complaint should be dismissed because of the following principles of his principles bar his defamation claim. Comedy, Uniform Foreign Country Money Judgments Recognition Act, collateral estoppel, which is here, Your Honor, defensive collateral estoppel, which is also known as issue preclusion. It gets a little confusing sometimes in these cases, and I'll try to take Your Honor through these to ensure that we have our distinctions. Thanks, Elaine. So if we need a breakdown of this hearing, we have the PowerPoint presentation, and now we have the hearing transcript. And you all have now heard me go through the court's ruling bit by bit. You're like, we know what comedy is. We know that none of this applies. But look at the Emily, are you distracted? Yes, this is the PowerPoint. It's introduction. Mr. Depp's complaint should be dismissed because the following principles bar his defamation claim. She reads from this to the court. She just reads from the PowerPoint to the court. Procedural chronology. And then she goes through it. Procedural chronology continued. Just what? Discovery in the UK and US. No lack of procedural tools. Well, we know the court didn't take that well under consideration. Here's the thing about the photocopied PowerPoint. I want to know, we know what this picture is because we've seen it in court, but good Lord, Elaine, the photos, the photocopy's so bad. It's just, starring Billy Bob. Okay, so these are we can kind of match the pictures, but like, what are these pictures? This is clothing racks, I think, turned over in the staircase incident, but these feel like x-rays or something. It's just Elaine. I wonder if she printed them out in black and white and then had them scanned in. Because it's just, I mean, this was written in gold. We saw all of these in the trial, so we can kind of guess, but it's just, what is happening? This is the broken bed photo. So this is Elaine's PowerPoint. So it feels like maybe we just need to go through the transcript and the PowerPoint now that I've said it out loud. I'm sure there will be other videos on it, but we will do that. Here's iconic. Look, when she talks about the UK, she uses the British flag. I don't know who made that choice to keep including the British flag. Wait. Oh, Bruce Springsteen's involved. We're definitely going through this. But somebody chose to put the flag in. And there's Pony Express Records versus Bruce Springsteen. We didn't hear about this in the ruling at all. So we're going to have to go through that Springsteen case because I'm fascinated. But this is the PowerPoint. Look. There's clip art of a gavel. Elaine, why? Why are we going with Black's Law Dictionary? I mean, I understand, but why? But why? But why the gavel? Defensive collateral estoppel defined. The court defined it really well in their ruling. I like that they used the Supreme Court of Virginia Richmond seal. I appreciate that. But I just, the bolding in different size fonts is giving you don't have a paralegal is truly what it's giving. Cause it is just a lot. Like the bold font is a lot. Like the formatting is just kind of a mess. And we're not here to critique PowerPoint skills, but Lordy, like this is like 10-point font. But then we've got like 14, 15-point font going up over here. Wow. It's yep. And then we're centered instead of just like justified in an indent. So someone said in the chat, as a paralegal, this is painful. This highlighting is not translating well into however the fuck they scanned this. And yep. We know the ruling, but it might be fun to go through this anyway. So that's, in things to come, we'll just go through that. Let's go through the entry of judgment now. Let's make sure that this is actually the entry of judgment. Yes, we'll go through the entry of judgment now. Some of that might be not on Elaine because some of these are also rough in the way they're scanned in, and that might be the court system, but some of the points of that PowerPoint are rough. So, all right. Judgment order. This is from June 24th. While the hearing was June 24th, this might have been uploaded to the court a day or two after. This matter came to be heard before a jury in this court beginning on April 11th, 2022, continuing day to day, April 11th through 14th, 18th through 21st. We're not going through the dates. It forever forever. This trial went forever. The jury deliberating May 27th, May 31st, and returning a verdict on June 1st. Before the jury were 3 counts of defamation brought by the plaintiff, Johnny Depp, and 1 count of defamation brought by the defendant, there were more. Amber Heard brought 3 counts too. Before the jury were 3 counts on each. Okay, whatever. They convicted on one, or not convicted, not criminal. They found liability on 1 count, but there were 3. But anyway, 1 count of defamation brought by defendant and counterclaimant plaintiff Amber Heard. At the conclusion of the trial and deliberations, the jury returned a verdict in favor of Mr. Depp on all 3 remaining defamation counts and awarded Mr. Depp $10 million in compensatory, $5 million in punitive damages, and a verdict in favor of Ms. Heard on her defamation count and awarded Heard $2 million in compensatory damages. It's interesting the way that's worded, because to me, they awarded her defamation on 1 of 3 counts, but we'll get to it when we get to the verdict forms. The jury verdict is hereby incorporated in this order and reference into this order by reference and made part of this order. It is therefore ordered that the jury verdict of $5 million in punitive damages in favor of Mr. Depp is hereby reduced to $350,000, the statutory cap pursuant to the Virginia Code. It's further ordered that with respect to the complaint, judgment is hereby entered in favor of Mr. Depp against Ms. Heard in the amount of $10,350,000 with interest at the statutory rate of 6% per annum. That means 6% per year. So whatever 6% of 10.3 million is, 6% per year, and then it'll reduce when Amber Heard pays. So if she pays multiple millions and it's only 6 million, then it'll be 6% of 6 million for the year. Ordered that with respect to the counterclaim, judgment is entered in the favor of Ms. Heard against Mr. Depp in the amount of $2 million with interest at a statutory rate of 6% per annum from the date of this order. So that is the final judgment. Enter the 24th of June. Everybody has to pay. Thank you, Amaryllis, for doing maths. We appreciate it. So 621,000, 6% per annum. And then that gets added. So that is the judgment. We're going to go through the rest of this and then talk about what this judgment means. But I want to get through the documents first. Otherwise, I'll sidetrack myself. Interestingly enough, Exhibit A are objections to the final order. I think this is laying the ground for Johnny Depp's appeal. I think we might see a Johnny Depp appeal based on this. Plaintiff and counterclaim defendant Depp objects to the final order on the following grounds. All reasons stated in oral and written arguments in Mr. Depp's demurs, pleas and bars, motions for summary judgment, motions to strike. All reasons stated in oral and written arguments in Mr. Depp's motions, jury instructions, and motions in limine. The court's legal finding that Ms. Heard could prove actual malice by relying on the mens rea of either Mr. Depp or Mr. Waldman and permitting Ms. Heard to argue the same to the jury in closing. So we're getting grounds for appeal. This could be a, hey, Your Honor, this is a mistake of the law. Actual malice had to be the actual malice of Johnny Depp and not the actual malice of Mr. Waldman, but allowing it to be interchangeable is improper argument. The court's failure to exclude inadmissible hearsay statements, the court's refusal to sustain Mr. Depp's objection to improper argument made by Ms. Heard's counsel during closing argument and motion for a curative instruction. They didn't object in time, I think. Ms. Heard's improper argument in closing told the jurors that a finding in favor of Mr. Depp would send a message to every victim of domestic abuse everywhere, which is an improper invitation for the juries to decide the case on larger social issues. I was going to say societal, because that's normally how I see it, but larger social issues, and to place themselves in the shoes of Ms. Heard when reaching their verdict instead of basing their verdict on the evidence presented, which also will be grounds for appeal if they appeal. That is a very succinct statement of what they are upset about. The jury's finding of defamation by Mr. Depp as to the statement made by Adam Waldman that, quote, and this is the one they convicted on, quote, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouse Penthouses thoroughly searched and interviewed and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their stories straight under the direction of a lawyer and publicist, and then placed a second call to 911. End quote. As contrary to the law and unsupported by the facts. That's going to be another grounds for appeal. The jury's award of $2 million in favor of Ms. Heard against Mr. Depp in connection with the jury's finding of defamation was excessive and not supported by the facts. All other objections by Mr. Depp stated in oral or written argument in the record on this matter. So I think they will absolutely appeal, and I think their grounds for appeal will be that the finding of defamation is unsupported by facts, so they legally cannot find that there's improper argument, and it is improper argument at closing. I agree that it's improper argument. Counsel's closing was improper, and that was Rottenborn's closing. But I don't think they objected in time to preserve it to preserve that issue for appeal, but we'll see. And then the court's legal finding that Heard could prove actual malice by relying on either statement, I think that'll go up on appeal. So those are the things I think they're signaling that they are going to appeal. Special verdict forms. So these are the verdict forms that the jurors entered. We looked through these so many times. These are the ones. This is the ones. These are the ones. These are they. These are they. These are they. The statements that the jury broke down, or the findings that the jury made. The answer is yes or no. So these are their answers. Count one, the headline, yes, defamation. Count two, 2 years ago, I became a public figure, yes, defamation. Count three, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse, yes, defamation. Jury awarded compensatory damages, 10 million, punitive damages, 5 million, June 1st. God, a month ago now. Special verdict form, Heard's claims. Do you find that Ms. Heard has proven all the elements of defamation? No. Move on to the next one. 3. As to this statement appearing, this is the ambush statement. Do you find that Ms. Heard has proven all the elements of defamation? Yes. Yes, defamation. Count 3. See, 3 counts. It should say 3 up above. Answer yes or no. No. Award 2 million, 0 in punitive, signed by the foreperson. And done. Here's what this means. A, we've seen objections now to the entry of the judgment. I think those objections will turn into an appeal. And I think it's going to be if you're appealing, we'll appeal. We are appealing. Everyone's appealing. We've already seen this ruling come up. Because with this ruling, we saw Johnny Depp being held responsible for the words of his lawyers, and the judge brought it up in the Gabby Petito hearing on the motion to dismiss. Already said, well, we just saw this happen in the Johnny Depp ruling, that the jury held him responsible for the words of his lawyer. I think they will appeal it. I think they will probably add the whatever their appeal bond is. I don't know, and I will go look at what Rob from Law and Lumber has to say about the appeal bond. I've seen that it's a $500 cost to appeal, and then the court sets the appeal bond. We will see what the court orders. We will see if Amber Heard's team makes an appeal to the court to reduce the appeal bond, the way we saw does anyone remember when we covered Haley Page? We need to get back to that case. It's still ongoing, I think. But they asked for a lower appeal bond in that case. So with that, we could see an appeal for a lower appeal bond, but from the entry of the judgment, the 24th, there are 30 days for the parties to file their appeals. So we will see these. We are not done yet. We will see the lodging of the appeals within the next 30 days if they are going to appeal. We saw reports coming out of court, and this was not aired, but we saw reports coming out of court that Elaine was asking for a briefing schedule and all this other stuff, and the court's like, you have 30 days. Do the thing. Do the lawyer things. You have 30 days. It's always 30 days. So you have 30 days to appeal. Could the parties still resolve the amount of legal fees? Yes. Yes, they can. They absolutely can resolve the legal fees. Or not the legal fees. They can resolve the fees from the appeal. They absolutely can, or not from the appeal, from the judgment. They can get together and be like, look, we agree, we'll stipulate to a lower amount. Do I think they'll do that before the appeal? Not likely. Do I think we can still see Johnny Depp's team asking for some kind of an injunction? Yes. Have we seen that yet? No. Could we see that in the future? Yes. So with that, the judgment is entered. The parties have 30 days to file their notice of appeal or file their appeal. And they've already noticed that they're going to appeal. Depp's team lodged their objections for the record, which I think preserves their right to appeal very well. And we'll see what happens next. This isn't done. It's like the trial's over, the verdict's in, but this shit is not done. And it's not going to be done for a while, which is wild to me. So let's go to the reports, because again, I don't have these court documents yet, but we're seeing multiple reports now of Johnny Depp having to pay the ACLU. Let's talk about that real quick. Johnny Depp and the ACLU. What happened? Well, Johnny Depp sued the ACLU to enforce the subpoena from the court in Virginia, and the ACLU turned around and was like, fine, pay us for the cost of complying with the subpoena. And we didn't get into that a ton, but we got into it some, that yes, there are some costs of complying. Oh, I'm shaking my own microphone. Sorry. Or my camera. There are some costs that you can have to pay when it comes to the subpoena. But if you remember, the ACLU was asking for $86,253.26. It seemed a bit excessive. Well, today, according to Law and Crime, and I have no reason to doubt these reports, Johnny Depp owes the ACLU $38,000 for attorney's fees for providing evidence for the fight with Amber Heard, judge rules. Actor Johnny Depp owes the ACLU $38,000 for attorney's fees in complying with a subpoena for evidence that he used in his defamation battle against ex-wife Amber Heard, a judge ruled Friday. Today. This was ruled on today. The award amounted to less than half the fees the ACLU requested. Yeah, because the ACLU fees were fucking wild. Attorneys like taxes are a fact of life, said Manhattan Supreme Court Justice Arthur Engoron. I hope I pronounced that right. Arthur, Lord of the Court. We're going to go with that. Who disclosed at the top of the hearing that he is a member of the ACLU. Of course he is. So many judges are. Judge Arthur, Lord of the Court, emphasized that nothing about his being a member would pose a conflict in the fee dispute. Okay. The ACLU's lawyer, Stephanie Teplin from Patterson, Belknap, Webb, and Tyler. Emily, how much do you hate pronouncing last names? All. How much do you hate pronouncing law firm names? All. Argued that $86,000 plus was reasonable reimbursement for production costs and expenses. And Gorin, that's the judge. And Gorin compared her prestigious firm to a Cadillac when all he said was needed for simple discovery was a Ford. Oh my God. Sometimes you don't want creme brulee. You are like a creme brulee. Sometimes you just want Jell-O. Your firm is overkill for what was needed for simple discovery. It's not our fault that they chose overkill, but they chose overkill. All of you that know what movie I am referencing, thank you for being my fucking people, Sarah. Thank you. Sometimes you don't want creme brulee. And I see everyone saying hi to Runkle in the chat. Give him his appropriate emoji. Hello, Runkle. It's good to see you. I see you by everyone saying hello to you. So hello, Runkle. Good to see you. Thank you, my people, for knowing what I'm talking about. I am referencing My Best Friend's Wedding. It's such a fucking good movie. Anyway, I would have lived if this judge had said, your firm is creme brulee, but all that was needed was Jell-O. I would have lived. You can never be Jell-O. Oh, Julia said you reference all my movies. It's because we're all the same. I don't mean we're all the same. The Law Nerds are such a massively diverse group of people, but we all at the core are Law Nerds and we like the same shit, which makes us all deeply connected. And I love that about this community so much, is that no matter how far or wide we live, how diverse we are at the core people. We are each other's people. And that is why I love this community so much, because y'all are my people. And creme brulee can never be Jell-O. And you know what, up in this chat, sometimes we're creme brulee and sometimes we're Jell-O. It just depends. We get to be a little bougie. We get to be a little basic. We love that about us. Let us continue with the judge going from the Cadillac to a Ford when he could have gone creme brulee and Jell-O. Your Honor, Lord Arthur of the court, this was a missed opportunity for a great movie quote. Missed opportunity. Anyway, compared her firm to a Cadillac, said that all that was needed was a Ford. Discovery is kind of basic. Lord Arthur of the court, Teplin. Who's Teplin? The ACLU's lawyer noted that Depp sought thousands of documents spanning a 6-year time period. Computers are a thing. And that New York law provides the reimbursement of reasonable production expenses to a non-party in litigation. She added that the ACLU made attempts to limit costs by limiting the scope of the subpoena, but Depp insisted upon the broader requests. Well, look, it was needed. The ACLU testimony was some of the most impactful testimony, I thought, in this trial. Truly, it was needed. I think the $36,000 that it's going to cost Johnny Depp in fees is absolutely worth it, because I think without the ACLU testimony, this case could have gone a different direction. I do. I think it was that important. That argument did not seem to move Justice Arthur of the court and his law clerk, who noted that the judge upheld the original scope of the subpoenas, noting that he did not follow Depp and Heard's blockbuster trial closely. The judge coyly asked how the ACLU got embroiled in the Hollywood legal battle. Your Honor! TLDR. Because they were, accomplices, essentially, in the defamation. The attorney for the ACLU did not answer that one directly, but her adversary did. Depp's lawyer, Jessica Myers. Jessica Myers, by the way, is the Heard from Brown Rudnick that did the direct examination of Depp, the one with the dark hair. That's Jessica Myers. She is from their New York firm. Brown Rudnick's got peeps everywhere. Depp's lawyer, Jessica Myers from Brown Rudnick, called the original request for fees exorbitant and unreasonable in a legal brief. Well, fair. Myers opined that the judge's final ruling was fair after he pronounced it. During oral arguments, Myers argued that any compensation would be unfair given the ACL's role in the editorial that led to the Depp Heard case. Thank you. Thank you, Jessica. That's what we were just saying. They were responsible for drafting and placing the op-ed that the Virginia jury found to be defamatory to Mr. Depp, Myers said. The defamation trial between Depp and Heard revealed the ACLU's role in crafting and placing the editorial at issue in the lawsuit. Also, thank you, Law and Crime, for just taking this one right down the middle. That's what it is. We appreciate that there's just facts. On December 18th, 2018, the op-ed ran under Heard's name with the title, "I Spoke Up Against Sexual Violence and Faced Our Culture's Wrath." That has to change. Her bio described her as an ACLU ambassador on women's rights. The same editorial now contains a lengthy editor's note disclosing that a Virginia jury found that 3 of its statements were defamatory, including the headline, and it listed each statement, which I appreciate. Mr. Depp should not have to compensate the respondents for the involvement in the tortious conduct, Myers added. Behind Heard's byline, the trial revealed, were several lawyers from the ACLU and her legal team. They carefully crafted it to avoid naming Depp or even explicitly claiming that her ex-husband abused her, or so they thought. Instead, the editorial statement that Heard became a public figure representing domestic abuse rather than a survivor of it, well, 2 years ago, the timing matters. The timing matters. 2 years ago, I became a figure. 2 years ago was when she accused her husband. 2 years ago. That is the point. So that 2 years ago mattered. Cutting that part out of the statement makes it seem more innocuous. I might have to take back previous statements. Instead, the editorial stated that Heard, quote, became a public figure representing domestic abuse rather than a survivor of it. That did not spare Heard from a stinging $15 million jury verdict against her, later reduced to 10.3 because Virginia law caps punitive damages. Jurors also found that Depp defamed Heard through one statement via his lawyer, Adam Waldman, awarding her $2 million. The math came out to a substantial win for Depp. Yes, they didn't give him any punitive damages. The ACLU's attorney denied the implication that the group was a tortfeasor involved in the tort. Oh, they define it. Keep reading, Emily. The term for someone who commits a tort. If y'all, David Dobrik is now an alleged tortfeasor. That's where we're at with that lawsuit. Oh, it's giving law school vibes, and I'm here for it. Depp's attorney said she didn't allege that, only that the ACLU was involved in one. How complicit was the ACLU is up to you to decide. We all watched the trial together. Depp's attorney argued that Heard used the ACLU to burnish her credibility, and that the civil rights group hoped to reel her in as a major donor. No, she was only a major pledger. Sorry, that just didn't pan out. When her divorce became finalized, Heard pledged to donate her $7 million settlement in full to two charities, half to the ACLU, half to the CHLA. Depp's attorneys made Heard's failure to follow through on those pledges a central part of their case. Yup. ACLU General Counsel Terrence Doherty testified that Heard donated only $1.3 million of her promised $3.5 million, mostly through contributions by wealthy third parties like Elon Musk. Internal ACLU emails revealed that their staff also pitched the editorial to the Post via an email stating that Heard was beaten up by Depp. I found that to be pretty damning testimony. Oh, Emily, keep reading. They attached it. Yay. The indirection of Heard's editorial ultimately didn't protect Heard legally. The jury found the op-ed defamed Depp by implication. They did. The ACLU has since faced criticism for its role in the celebrity spat. I think that downplays it. Thunder. Tell me what you think. Critics said that the group misled the public about the nature of Heard's pledges and betrayed its commitment towards due process for those accused of a serious crime. And they attached it. Way to go, Law and Crime. Thanks so much. Here we go. The legal document. Attorney's fees, $38,000. The end. Page 1 of 1. Well, that was thrilling. All right, well, Johnny Depp has to pay the ACLU $38,000 in legal fees for their role in defaming him. I mean, that's not what I mean. For their role in providing the discovery that helped him win his case. That frames it better, but also. So, is the $38,000 worth it? I think it is. Kimberly Roddy Mom says I'm 48 minutes behind. Has Emily gotten tipsier in that time? Chat, I'll let you answer that. Because, well, we don't always perceive ourselves clearly after the whiskey. All right, well, I'm not surprised by it. I'm glad that the court cut it down. I think it's appropriate that the court cut it down from the $68,000. I think for Depp, it's absolutely worth the truth coming out and the ACLU testifying. Absolutely worth it. Absolutely worth it. Also, we're going to have to add tortfeasor to the law nerd dictionary under person who did that shit. or is alleged to have done that shit. Newsweek also reported on this. Should we see what they have to say? I don't know. I kind of love them for Tug's tits, but I kind of also am still floored that Newsweek actually published that article from Dr. Spiegel. I'm still surprised that that happened. But let's just see what they had to say real quick. Either way. All right. Johnny Depp ordered to pay ACLU over Amber Heard evidence. Judge. What? Just Johnny Depp ordered to pay ACLU over Amber Heard evidence. Judge. What does that mean? Have I had to? I don't know what's happening here. Let's make that stop, please. I don't know what's happening there. But what does that sentence mean? A month after winning a defamation case against his ex-wife, Amber Heard, Johnny Depp now has to pay the ACLU $38,000 in attorney's fees in complying with a subpoena for evidence that was used in the trial, a judge ruled. Just judge. Judge author of the court. I agree. During the trial, the ACLU demanded $86,000 from Depp as reimbursement for the production expenses, arguing that the reimbursement was for considerable expense spent responding to onerous subpoenas served by Depp from an underlying action in which neither the ACLU nor any of its employees are a party, according to Law and Crime. Oh, good. Newsweek's just reporting on Law and Crime's homework. Fantastic. The ACLU's lawyer said that the $86,000 was reasonable. The judge said, "You can never be Jell-O." We're just rewriting this ourselves. On Friday, the Manhattan Supreme Court Justice Arthur, king of the court, ruled that the ACLU was to receive $38,000. When contacted by Newsweek, an ACLU spokesperson wrote, "We are pleased that the court recognized that the ACLU complied with Mr. Depp's request and did so at great expense. The ACLU were responsible for drafting and placing the op-ed that the Virginia jury just found to be defamatory to Mr. Depp," Myers said, according to Law and Crime. Okay, the rest of this is just Law and Crime's homework. Great. Perfect. So with that, we're going to move on to something that is, well, I don't know if defamation's a light topic, but the ACLU not getting the full amount that they're asking for is kind of a light topic. But we've got to move on to the Petito versus Laundrie ruling before we get to questions at 2 hours. And we just stream forever now. That's just what we do. You've probably followed the Petito Laundrie case a little bit. With that, the current case is the Petito family, Gabby Petito's mother and father, suing Brian Laundrie's parents. The civil case is essentially a intentional infliction of emotional distress case. It is going to be a difficult lawsuit no matter how you look at it, because the argument from the Laundrie family is that we didn't have a duty to do anything. We don't owe a duty to the Petito family. And again, morality, legality, in this case, you are going to have to just separate the two and go with, we're talking legality. Over here is morality. Morality feels one way. Legality is what's happening. Whether the Laundrie family owed a duty to the Petito family to help them find Gabby Petito if they knew where she was after Brian Laundrie returned to Florida with the van without Gabby Petito, and then what happened there. This is a difficult case. I still think, and this is just Emily thoughts, I still think the purpose of this case is discovery. And they are now successful in moving forward to discovery. And I think that that's the point of this case. I don't think winning is the goal here. I think there's enough for them to file a case without it being completely legally improper. You know, you have to have grounds to file a case and survive a motion to dismiss like this. A motion to dismiss, we'll talk about the standard for the motion to dismiss in a moment. But with the motion to dismiss being survived, we now move into discovery, which means the Petitos or their lawyer, and I call them the Petitos because Gabby's last name was Petito. I know that her mother has a separate last name, Schmidt. I don't mean any disrespect to her mother. I lump them together instead of doing Petito Schmidt or Petito and Schmidt, but Gabby's mother and father. So with that, they get to discovery, meaning that they can now propound discovery, requests for admissions, interrogatories, like we're breaking down in the Britney Spears case. Yes, there is so much that happened in that case. We're going to get to it Tuesday. But they can start serving deposition subpoenas to make the Laundries sit down under oath and answer questions about what they knew and when, to start getting discovery from potentially law enforcement, the FBI, and others about what was known and when. I think discovery is the point here, and I think it's the bigger point than winning some type of monetary judgment. Money isn't going to do anything for the Petitos. Information might at least give them closure. And so I think that's what they're seeking. That's just what I think they are looking for in this. So they are now moving forward to discovery. It does not mean this case survives long term. This case could still get dismissed down the road on a motion for summary judgment. That can still happen. Can this case go to a jury trial? Maybe. But I think it's very difficult. I really do. I think it's a difficult legal theory, but I hope they get answers. So let's go to this judge's ruling on the motion to dismiss. The motion to dismiss, I broke down on Thursday after the hearing. I watched the hearing myself so that I could break it down with you. And the judge did bring up the lawyer's statement in the Depp Heard case and Johnny Depp being held responsible for his lawyer's statement. The lawyer's statement was a big factor in this court's ruling. On a motion to dismiss, the court takes everything at the light most favorable to the non-moving party. So the plaintiff, in this case, the Petitos. Everything is taken in the light most favorable to them. So if there's something that needs to be assumed or presumed, it's just all taken in the light most favorable to them. Even in the light most favorable, this case can't survive. And the court ruled that that is not the case here. If it doesn't really matter. I'm not going to go into if this had been granted, because it's not being granted, so we can just move on. Order denying defendant's motion to dismiss. Defendants, the Laundries. Before the court is defendant's motion to dismiss the amended complaint. The plaintiffs filed a response. The defendants filed a reply. The court conducted oral argument. Today's ruling does not determine what happened to Gabby Petito. Instead, today's ruling is technical in nature. Legality, not morality. It determines only whether Gabby Petito's parents stated a valid claim against Brian Laundrie's parents. Because the Laundrie statement by their attorney in the context of the unique facts of this case is objectively outrageous, not outrageous Britney Spears, outrageous intentional infliction or negligent infliction of emotional distress, outrageous outside the bounds of civilized society for those types of torts. The court concludes that plaintiffs have stated causes of actions for intentional infliction of emotional distress against the Laundries. The court denies the motion to dismiss. The amended complaint and its allegations of fact. The operative complaint is the amended complaint, and each of the 4 counts purport to state a cause of action for intentional infliction of emotional distress based on the same allegations of fact. The plaintiffs are Joseph Petito and Nicole Schmidt, the parents of Gabrielle Gabby Petito, who is deceased. The defendants are Christopher Laundrie and Roberta Laundrie, the parents of Brian Laundrie, who is deceased. Each plaintiff sued each defendant. To avoid confusion, the court refers to the individuals by the first name instead of their last name. Under Florida law, the court must assume all well-pleaded facts are true in a ruling of a motion to dismiss. We went through that standard. All assumptions go to the plaintiff. In July 2020, Brian and Gabby became engaged to each other. The following year, in July 2021, they left New York in Gabby's van and headed west for a van life trip. We went through this in the complaint. Brian murdered Gabby on August 27th, 2021. Brian, and again, we're going to do this one more time. This is taking the things in the complaint as true. Now, we know that Brian's notebook has been released. We know that the investigation into Gabby Petito's homicide has been closed. We know that Brian Petito took responsibility in his notebook for the murder of Gabby Petito. So even though the judge is stating it here as fact, the judge is taking the facts from the complaint into this ruling and not saying, I believe this. And that's why the judge laid it out at the beginning, knowing that people could seize on this language saying, see, the judge said Brian Laundrie murdered Gabby Petito. Well, Brian's notebook seemed to say that too. So let us continue. Brian murdered Gabby Petito on August 27th, 2021. Brian then texted between his and Gabby's telephone to hide the fact that Gabby was dead. Brian would continue to send texts from Gabby's phone until at least August 30th, in which Brian disguised as Gabby texted Gabby's mother, stating there was no service in Yosemite Park. Brian did this to suggest that Gabby was still alive. Gabby was 22 years old at the time of her death. On August 28th, 2021, Brian told his parents that he murdered Gabby. Again, these are the allegations in the complaint. These are allegations that the court is taking as true for the purpose of this ruling. Do not take these as hard, dyed-in-the-wool facts, because in the context of this ruling, these are still allegations that the court is taking as true for this ruling. I think I've stated it enough. Y'all know what it is. That same day, Christopher and Roberta spoke with an attorney, and they would send the attorney a money retainer several days later. On September 1st, 2021, Brian returned to his parents' home in Northport, Florida, driving Gabby's van. Brian and his parents then vacationed together at Fort DeSoto Park in September 6th and 7th. They took this vacation, each knowing that Gabby was dead and that her parents were frantically looking for her. On or about September 10th, Roberta blocked Nicole on Roberta's cell phone and Facebook. On September 14th, and fully knowing that Gabby was dead and knowing the general whereabouts of Gabby's body, the Laundrie's attorney released the following statement. This is the key to the ruling. It is our understanding that a search has been organized for Ms. Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope, that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family. On September 16th, the attorney for Gabby's family issued a letter to Christopher and Roberta, which read, "We are writing this letter to ask you to help find our beautiful daughter. We understand that you are going through a difficult time and your instinct to protect your son is strong. We ask you to put yourselves in our shoes. We haven't been able to sleep or eat and our lives are falling apart. We believe you know the location of where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how can you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family have any decency left, please let us know where Gabby is located. Tell us if we are even looking in the right place. All we want is Gabby to come home. Please help us make that happen." Christopher and Roberta declined to respond to either Joseph or Nicole, instructing all communications be made through their attorney. Their attorney would issue a no comment when asked about Gabby. They did this knowing of Joseph and Nicole's mental suffering, and by advising where Gabby was, they, quote, could have prevented such additional mental suffering and anguish of Joseph and Nicole by disclosing what they knew about the well-being and location of the remains of Gabby. Yet they repeatedly refused to do so. Continuing, Joseph and Nicole further alleged that Christopher and Roberta, quote, acted with malice or great indifference to the rights of Joseph and Nicole. Analysis. A note about legal duty. Laying aside for the moment the statement that the Laundries made through their attorney, the other conduct plaintiffs complain of mostly involves the Laundries failing to act. Specifically, plaintiffs seek to fault the Laundries for not telling the plaintiffs that Gabby was dead or where her body was located. The Laundries frame their quote-unquote silence in constitutional terms, arguing that their silence was constitutionally permissible under the First, Fifth, and Sixth Amendments. to the United States Constitution and the related Florida Constitution provisions. It's interesting that they believe that the Fifth Amendment applied here, because the Fifth Amendment applies when you believe that you can be brought up on a crime. The court does not believe it is necessary or appropriate in this case to resolve these constitutional claims on a motion to dismiss. The contours of the facts are not sufficiently distilled to apply these important guarantees. The claims are more appropriately addressed, if at all, at the summary judgment stage. Summary judgment is after or substantially through discovery, where more facts are brought saying, Your Honor, this can't even go to a jury. Legally, this can't survive. So it's a motion to dismiss after the discovery is in and more evidence is prepared. It's a lot of what I did as a research attorney, was going through lengthy motions for summary judgment. Plaintiffs, during oral argument, candidly conceded they struggled. They did. This attorney said it twice. Plaintiffs, during oral argument, candidly conceded that they struggled with the legal duty owed by the Laundries to them that would have required the Laundries to break their silence. Required is key. Plaintiffs appear to conflate morality with legal duty. Your Honor, we call that legality and morality over here on the YouTubes, just on my channel. The plaintiffs appear to conflate morality with legal duty. Plaintiffs have not identified, and the court is unaware of any legal duty the Laundries would have owed to plaintiffs to tell the plaintiffs that Gabby was dead or the location of her body. Morality, legality. Further, the plaintiffs point to no duty that the Laundries were under to accept text or social media messages from plaintiffs or refrain from taking a vacation while the plaintiffs searched for Gabby. Legal duty different. It's shitty. It's shitty is not a legal duty. That's where the morality comes in. And the court says, but here we are. I'm going to make this big because this is important. If the facts of this case were truly about silence with no affirmative act by the Laundries, the court would have resolved this case in the Laundries' favor on the concept of legal duty, or more precisely, the lack of any legal duty for the Laundries to act. Had the Laundries truly stayed silent, the court would have granted the motion to dismiss in the Laundries' favor. But they did not stay silent. The Laundries spoke. The Laundries' attorney released a statement that plaintiffs argue was outrageous under the facts of this case. Plaintiffs sufficiently alleged that the Laundries spoke. Quote, Christopher Laundrie and Roberta Laundrie, through their lawyer, issued the following statement. At oral argument, the Laundries contend that there was no allegation in the amended complaint that their attorney knew that Gabby was dead or the whereabouts of her body when he released the Laundrie statement. That position is meritless for at least three reasons. First, and this is getting into the acting as an agent and taking on the mindset of the agent. First, generally, an attorney serves as an agent for his client. The attorney's acts are the acts of the principal or the client. Second, all the facts and reasonable inferences are construed in favor of the non-movement, here the plaintiff. A reasonable inference is that the attorney knew the same information the Laundries knew. So that's where these reasonable inferences, the inferences that can be drawn, go in favor of the Petitos. Third, the words used in the statement indicate the Laundries agreed to it. It provided our understanding, and on behalf of the Laundrie family, it is our hope, Certainly, there's no allegation in the amended complaint that the Laundries disavowed this statement. For the purpose of the motion to dismiss, the court must assume that the Laundries are responsible for authoring the September 14th statement issued by their attorney. The statement. The Laundries contend that their statement is not outrageous as a matter of law. And this goes to intentional infliction of emotional distress. We've broken down the legal grounds for outrageous, and I think the court will get to it in due time. At oral argument, they suggested it merely was a plain statement. Plaintiffs, in contrast, contend during oral argument that the statement was knowingly false, designed to create false hope, and issued by the Laundries, who knew Gabby was dead and where her body was located. I kind of disagree with the Petitos on this because I see where the statement could be read as neutral. I don't think that helps for a motion to dismiss, but I can see where you can argue the statement is neutral, saying, you know, we hope the search is successful and that Miss Petito is reunited with her family. I don't think that indicates the state of the reunification, but that is, again, legal parsing, not more than that. So let's get into the statement as the court sees it. The Laundries contend the statement is not outrageous. Plaintiffs countered that it was designed to create false hope and issued by the Laundries, who knew Gabby was dead and where her body was located. The statements or the elements of IIED and the contours of that tort have been described by the Second District Court of Appeals as follows. This is the court that governs this jurisdiction. To state a cause of action for IIED, and these are pretty similar jurisdiction to jurisdiction on this cause of action. We've looked at IIED now in Georgia, in New York, in Washington, and in Wyoming, I think was the other one. We've looked at this. It mostly comes from the Second Restatement of Torts. It's generally the same or similar. Deliberate or reckless infliction of mental suffering, outrageous conduct, that's legally, beyond the bounds of a civilized society. The conduct caused the emotional distress. The distress was severe. I think, well, you guys let me know what you think. The deliberate and reckless infliction of mental suffering is going to be hard. Is the statement enough for it to be deliberate and reckless? Outrageous conduct, I think a jury will find outrageous conduct. The conduct caused the emotional distress. That might be difficult too. There will be argument, if this ever went to trial, that the emotional distress is not caused by the statement, but caused by the search and the unknowing and the loss of their daughter, and that the distress was severe. Again, it needs to go back to the conduct caused the emotional distress, and they will argue about whether or not the conduct actually caused this emotional distress. Behavior claimed to constitute an IIED claim must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. In applying that standard, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of IIED occurred. Rather, the court must evaluate the conduct as objectively as is possible to determine whether it is atrocious and utterly intolerable in a civilized community. So that's the determination if this went to a jury. Whether conduct is outrageous enough to support a claim of IIED is a question of law, not a question of fact. Well, the jury's the fact finder. It has to get past the judge first, they say. The court focuses on the second element, outrageous conduct. Both sides presented several cases for the court to review, suggesting the conduct alleged in this case either was or was not outrageous, as they're wont to do. An important lesson from the cases cited by the parties is that context matters. Conduct viewed in isolation as being insufficient to state a cause of action, when considered with other conduct, may be considered sufficient to state a cause of action. In Human, it says stuff that on its face, like this statement, that may seem neutral, in light of everything going on, is not perhaps neutral. And so the court says context has to come in here. The court, the wrong button. The court goes on and cites Stedman, where the Second District concluded an insurance company delay in approving a double lung transplant after being ordered to do so by a judge, by itself did not rise to outrageous conduct when paired with other conduct, such as knowledge that the delay would speed up the demise of the insured. The delay in approval rose to the level of outrageousness to state a cause of action for IIED. That case, based on the lawyers arguing, seems horrific. And again, have you read this case, Emily? No. Are you going off what the lawyers argued during this hearing? Yes. It seemed that this case was surrounding an insurance company not approving a double lung transplant and then dragging their feet, hoping that dragging their feet would resolve the issue in that the insured would pass. Yep. And so when they said, well, is denying the claim or delaying the approval of the claim after it's ordered, is that outrageous? Well, on its face, no, it's not. But when you look at everything else, you're like, oh, fuck, that's fucked. And that's kind of the level that they're talking about. Is this to the level of, oh yeah, that's fucked. That's outrageous. And then the court evaluates that. The words used by the Laundries on the surface initially do not suggest outrage, quote, and then they read it again, or they recite it again. When juxtaposed with the other conduct in the case, though, the outrageous threshold is surpassed. As alleged by the plaintiffs, the Laundries made their statement knowing that Gabby was dead, knowing the location of her body, and knowing that her parents were frantically looking for her. If this is true, then the Laundrie's statement was particularly callous and cruel, and it is sufficiently outrageous to state claims for IIED. And that's where we get to what comes up in discovery. If in discovery they can prove that the Laundries knew that Gabby was dead, knew the location or rough location of her body, and knew that her parents were looking for her, which we already know is true. So really, that they knew she was dead and that they knew the location of her body, then we're going to get past even a motion for summary judgment, and this will see a trial based on this court's ruling, or could see a trial. I don't see any of this resolving. You can't put this case in front of a jury if you're the Laundries. This case does not go well for you if you get to a jury, because a jury, the facts are fucking horrific. They just are. And juries parsing legality and morality is very difficult. And this case is going to play heavily into emotion. So with that, they're going to have to, in discovery, prove that they knew that Gabby was deceased and that they knew roughly where she was. The court identifies two cases that support the court's decision, although neither were necessary for the court to conclude the amended complaint stated a cause of action. And then the court cites the two cases that they relied on. And then there will be no avalanche of litigation. The Laundries argue that denying their motion to dismiss will result in an avalanche of litigation. This is a very limited and specific type of a case for emotional distress. What the Laundries were, through their attorney, they weren't present in court. What the Laundries were implying was that anytime someone remains silent, they can be sued for this. And that's not it. So the Laundries argue that denying their motion to dismiss will result in an avalanche of litigation for situations where relatives of tort victims receive bad news about family members. They base their argument on MM versus MPS. The Laundries argument misses the mark. In MM, the tortfeasor all the day with tortfeasor. Add it to your lexicon. Feel comfortable using legal jargon in everyday life. Tortfeasor should have been a drinking word for tonight. We should have just done it like Watch What Happens Legal. Tortfeasor being the word. I didn't know tortfeasor was going to be so readily brought up as we got deep into this. I didn't know it was going to come up in the other case in reference to the ACLU. But here we are, all of the tortfeasoring. Now we know what tortfeasor means. See, it got defined in the other one. And now we're bringing it into this one. In the MM case, the tortfeasor told the parents of the victim that the tortfeasor had essayed their daughter. This is darker than I intended. I didn't intend for it to be dark. This is darker than I anticipated. That the tortfeasor has essayed their daughter and that the tortfeasor's wife had supplied illegal drugs. Okay. The parents sued the tortfeasor based solely on their distress from the tortfeasor's disclosure to them. The daughter separately sued the tortfeasor based on the tortfeasor's essay. The third district held that the parents had no cause of action under those facts. The court remarked that receiving bad news about family members was insufficient for a claim where there is no attendant intentional or reckless conduct directed towards them. The court has no quarrel with the holding, and in fact, it is consistent with the court's decision today. The facts of MM simply are distinguishable because this says but I think it's there, were no facts in MM suggesting. It's so nice to see that I'm not the only one that makes typos. Sometimes I'll clown on attorneys when they're bad, but this is just the court saying instead of there. Because there were no facts in MM suggesting the tortfeasor directed any conduct towards the parents. Here, plaintiffs allege that the Laundries issued a public statement of false hope, knowing Gabby was deceased and the location of her body, while her parents were frantically searching for her under mysterious circumstances. The two factual scenarios are readily distinguishable. There will be no avalanche of litigation based on denying the motion to dismiss. A parting thought. Thank you, Your Honor. I like this judge already. The court is aware the Laundries have made additional arguments in their filings and at oral argument to support their motion. The court need not detail those except say none are sufficient to preclude the court at the motion for dismiss stage from concluding that the amended complaint states a cause of action. And that's really it. Is there a cause of action here? Yes, there can be. Enough to go forward to discovery. And I hope that discovery helps uncover the truth. Truly, legality, morality, I hope that it uncovers the truth. Will that potentially lead to, and everybody wants to know if somebody's going to jail in this case, will that potentially lead to more? Unknown. So far, whatever the FBI has seen, whatever the police in Northport have seen, it's not been enough to charge the Laundries with accessory after a fact, aiding and abetting after the fact, obstruction. I don't think we haven't seen enough to see if there's been obstructive statements from the Laundries to police. Remaining silent is not obstruction. So we'll just have to see. But this is a civil case. Anything uncovered in the civil case that could push this towards a criminal case? I don't know. We'll see. We'll just have to see. And I know there's a letter that came to light that said burn after reading. I don't know all of the circumstances of that. They are not in front of this court at this court, not me. I don't mean this court. I'm not referring to myself in the esoteric third person as they're not in front. No, that court in Florida. They're not before the court in the civil case yet. If all of that comes into that case, we will talk about it. The notebook that has had pages released will absolutely come in. And then we will see. We will see what happens. I'm going to be following this until there's some resolution of this civil case. There is another civil case going on, the estate of Gabby Petito suing the estate of Brian Laundrie. It seems like that's going to go to default judgment. I talked about that last week. So I have questions. You have questions. We have questions. I've had whiskey. We should do questions at 2 hours and 30 minutes in to the 15,000 of us that are still chilling on a Friday. Hey, I'm going to get to some super chat questions. Go ahead and put your questions in just like this. AM, thank you for leading by example. Putting question or Q or like a question mark, like the letter Q or like a question mark will help me see them so that I can answer. I try not to just answer super chats. I try to make sure that we can answer all the questions because I love chatting with y'all. I feel like we have done so much. Will we get to see the discovery in the Petito case? Only if it comes into the motions. It won't all be in court. That'll be between the parties. So unless it comes into motions, we won't get to see all of it. So unless it comes to trial. But if there's further motions, like a motion for summary judgment, a lot comes in a motion for summary judgment. So if that happens, we'll get a lot more information. But this will probably be quiet for a little bit as it goes to discovery and they start issuing discovery subpoenas, unless there's a discovery fight. God, that would suck. Could you imagine if the Laundries start acting like yeeted spears with this discovery, being like, no, I'm not going to be deposed. You be deposed. Ugh, that would be awful. That would be awful. It was a healthier pour than I anticipated, but it was delicious. So that's where we're at. I noticed some of you have mentioned my flush reflex. Yes, when I did all of my genetic testing, I absolutely flush when I drink at all. I'm translucent. There's no hiding it. So I do. I flush when I drink. Even if it's just a little bit, I flush when I drink. So question, what do you think will come into the motions? I mean, that's all speculation. And I don't know yet. We'll see. Question, could the Laundries avoid discovery somehow? It would not be wise, Michelle, because then there will be motions to compel discovery. Your discovery obligation is your obligation. It's an obligation. Thou shall. And if it comes into court, it's just going to be worse. Like, we keep learning more and more information about the Britney Spears case going on. Well, the conservatorship because of what's going on in discovery. So if they fight discovery, it's a way for the Petito's attorney to put way more information into the public. So that'd be a terrible idea, but we'd get to see a lot of stuff. So, okay. Who said cat? Kate. I'm very suspicious of Brian's notebook. Too many inconsistencies. I don't know about the veracity of the notebook. We will see. Question, did you see the Marilyn Manson defamation case? I've seen it. I have not had a chance to read it yet. So I've seen it. Head in the clouds. They didn't remain silent. They teased Gabby's parents. They didn't remain silent. And the court said if they had absolutely made no statement at all, this case would have been dismissed. And that's a very interesting thing. Couldn't the Petito family sue for loss of consortium? And Gina, you mean in the care and comfort of having a daughter sense? Could they sue the Laundrie family? No. Could they sue Brian Laundrie's estate? It would be tough, and I don't think it would get them any answers because I don't think anyone for the estate would show up. So it goes to a default judgment and gets you what? I think they want answers. That is my gut sense of this case is they were not given any answers. They know that there are people alive that have answers about the death of their daughter, and they want fucking answers. And who can blame them? Who can blame them? They want answers about what happened to Gabby, and they believe the Laundries have it, and they are going to do what they can to try to get those answers. I don't blame them. I don't blame them at all. It's a shame that they're going to have to spend the money to go through litigation to try to get those answers. It truly is. After, the Laundries are just the Brian Laundrie's deceased, Gabby Petito's deceased. Nothing's going to bring them back. So to give the Petito family answers, I don't know what harm could come from that, but I think there's a harm worried about for the Laundries. That's because they are and have been very closely guarded. So, and we'll see. We'll see. Sue said lighted lip gloss want. These, the links are always in the description of the videos. I have to put the links into the Facebook ones after the video goes live, but they are Gerard Cosmetics. There's a Lawnard code. I believe the code is Lawnard. The mods will let me know for sure, but I believe the code is Lawnard at Gerard Cosmetics. And yes, they light up and they have a mirror so that if you are I would say if you're in the club, that's not true for me anymore. If you're at a concert or in a dim steak restaurant having a date night with your spouse because you like a good steak, you can see your lips while you put on your lip gloss because there is a mirror. Ways you know that a makeup brand is woman owned. That. It lights up. I love it. Though there was that one time at the karaoke bar where it came in very helpful and people were like, it lights up. I was like, yes. But that's a story for another day. That's a story for another day. Ice Guy said, I wagered the Laundries settle. They might want to. I don't know if the Petitos will settle with them. They want answers. If they get answers, maybe they would. So, Chris George, these are the real questions we need to get to this evening. How do you feel about USC and UCLA joining the Big Ten Conference? It's weird to me as a lifelong USC harasser and UCLA fan. It's just weird. I was asking Dr. B about it today. I was like, what do you think of this? He's like, I don't know, maybe it's better for them. I don't know what the benefit for them is to join the Big 10. And then do they change the Big 10 to the Big 12 and then the Pac 12 becomes the Pac 10? I don't know. It's weird to me. Does it only affect football conferences? Someone needs to explain the sports balliness of it all. Does it affect all sports? Because I think some of the conferences for polo are different, but it's been a long time. So, question: wouldn't the Laundrie's failing to report Gabby missing be actionable after their son returned with her van and without Gabby? No. They are not required to report her missing. Nope. So, question: what kind of whiskey was that? The delicious kind. It was Old Smoky salted watermelon whiskey. It's delicious. Look, I love a flavored whiskey. So we were out of town for a funeral, and I wish I had written it down because I forgot. We found a restaurant that we really enjoyed, and my family, being my family, who does, all of us are the same way. We very much thrive with familiarity. So we found a restaurant we liked, and we're like, this is where we're going for dinner every night. They had the most delicious chocolate whiskey. It was so smooth. It was so good. It was just, so now I need to find a chocolate whiskey. I love a flavored whiskey. I know I'll get clowned for the whiskey purist out there, but I love a flavored whiskey. So, did you ever talk about the R. Kelly sentencing at the beginning of the show? I sure did. JL cupcakes. I want a date night with my spouse. It was lovely. It was really lovely. We had a really, really nice time just listening to really loud music and literally sweating so much. This is definitely the difference between going summer concert season in Nashville, Tennessee versus Southern California. In Southern California, you get a cool breeze at night. Hot, sweaty, hot. Sweaty, hot. Could the Petitos refuse a settlement? Yes, they sure could. The Petitos can choose to settle or not. Big 16. I don't know. Well, chat, you guys let me know. What you think about UCLA and USC joining the Big 10. Now being something else. I have a caramel turtle chocolate whiskey. It's amazing. Lisa Lynn, that sounds amazing. That sounds great. Canadian maple whiskey also sounds delicious. We love a flavored whiskey. Call the restaurant that had the chocolate whiskey. That's a great idea. Coming in with the logic, Cicely. Just call them. Oh, just call them. Yeah, I will absolutely do that. The humidity makes a difference, and the heat. We drank a lot of water last night. What happens if Heard can't pay Depp? I believe Law and Lumber did a video on this. I think Joe Neerman over at Good Logic has also talked about this. Joe Neerman has done, I think, of everyone that I've had conversations with, has done the most in the very specific area of law of recovery. But they can start attaching her property, trying to get her to sell off property, things like that. So they can go after future residuals. There are things they can do, but it's not just over. How many of you remember when I talked about the Keemstar Romeo Lacoste suit? Some of you might. Some of you, a lot of you are new since I talked about the Keemstar Romeo Lacoste suit. Keemstar and Romeo Lacoste sued Keemstar for shit Romeo Lacoste said. I know, don't ask. It got dismissed at a anti-slap in California. Keemstar won the anti-slap and then is entitled to what? Attorney's fees. It seemed that Romeo Lacoste couldn't maybe afford the amount of attorney's fees that were awarded, so settled for a lesser amount of attorney's fees, and Romeo Lacoste had to give Keemstar his gold play button. And Keemstar took the gold play button. I think it's up on his YouTube channel. I know it was on Instagram. Took a Sharpie and crossed out Romeo Lacoste's name and put his own name on the gold play. Oh, George, you scared me. Hi, buddy. Oh, no, that's Fred. Hi, bud. There was a cat at my feet. So took the gold play button. So you can still settle even after attorney's fees are awarded for property in kind. You can just come up on the buddy boy. He's just like, hi. So anyway, I don't know what brought that up. Something with attorney's fees and what happened if somebody can't pay. But you can settle. Don't the Laundries have to pay out of pocket to defend the Petito case? Yes, they do. If they have to settle, won't that be out of pocket as well? Yes. I can't imagine home insurance would cover an intentional tort. It generally doesn't, and this is alleged as an intentional tort. Isn't Tennessee the whiskey capital? I think so. Tennessee loves its whiskey. I love the Tennessee whiskey. I love it. Hi, look, if you want to come up, just come up. This cat is trying to like squeeze up onto my lap. Hi. He just wants to be a lap kitty tonight. All right, come on. Are we just... Yep, we're just sitting on the lap. All right. Do you want to say hi? Fred's like, hi, law nerds. We're just about done for the night. We want to be on the lap. So I'm going to be covered in cat hair. I know, it's summer. All the hair, all the fuzz, all the little fuzz. Maybe we'll lay down on the desk and then, nope, that's not happening. Whatever would Depp have to pay the ACLU for? The cost of discovery. Under New York law, it is proper that a non-party litigant who has to propound discovery who has to be compelled to propound discovery, can have the cost of propounding that discovery taken care of. So, what is the name of the restaurant? It was Highway 178. It was really good. Have you tried peanut butter whiskey? Yes, we have peanut butter whiskey. Has Emily talked about... I now have cat hair on my lip gloss. No, not yet. It's on the list. We are at Code Fred. Oh. Thank you, Stunt Brat 777, retired stunt woman. After 23 years, that the conversations and the things you must know, fantastic. I have no idea how to pronounce that, but that sounds like it might be right. All right, peanut butter whiskey is very smooth. There are two peanut butter whiskeys. So Old Smoky has a peanut butter whiskey. Screwball, I think, is the peanut butter whiskey, the one with the sheep on it. But then Tennessee Legend has a peanut butter cup whiskey. Here is the difference. The peanut butter cup whiskey, it has a hint of chocolate to it. It's so good. LA divorce attorney on Popcorn Planet said the judgment was dischargeable in bankruptcy. I respect Christopher Melcher. I respectfully disagree. It is an intentional tort. I don't think the entire judgment will be dischargeable in bankruptcy. I think they could try. I think it will be a lot more litigation. I think they're going to try to appeal first, but I don't think it will just be done. We were talking about you. We said Octo 3 times and we summoned him. All right. This cat is going to try to, he is seeking my attention. And is going to he's just trying to get me to pet him, and he's going to end up wiggling his way right off of my lap. All right, we got to get to a few super chats. Thank you, Jillian. Excited you are doing so well. I mean, we're exhausted at the moment. Because here's the thing about travel. There is vacation, and then there are trips. This was a trip with the family. We had great moments. We spent great time with family, but there was no downtime. I had a book. I didn't get to open it once. I love to read on vacation. I love having downtime. There was a lot of go. We did have a delightful day in the river. It was great, but it was not a lot of downtime. So it was a trip, but it was busy, and I am tired. I did not sleep great. The second hotel we were at was not very comfortable. Oh, Livs is inside again. I missed your lovely content all week. Hope you had a great break. It was good. It was good. The nice thing about break is a little bit of a break from social and a little more time out in the woods with the kids was really, really good. I like being out in nature, even when it's hot. I like not having to worry about just, on a river day, it's like, fuck it, we're just dirty. It's kind of great. And I love that. So it was good. Summer Savage, so happy to see you. Catch us up so much. What were the Chrisleys indicted for? There is an entire episode of the Emily Show podcast that breaks down the Chrisley convictions, not just the indictment. There's more Chrisley stuff going on. We need to be back for. I've slated that right now for Tuesday, unless other fuckery pops off, to talk more about the other Chrisley lawsuits after the conviction. Tracy said, "Why do you think Johnny Depp's team has not filed for an injunction?" I don't know. Do you still think one is coming? It's possible, unless they're just like, fuck it, let's go. I don't know. So I'm surprised they haven't. Maybe they want to keep seeing what she says. It's possible. This has to be a strategic decision. I mean, obviously. Fred, what are you doing? We need like a lap camera at this point. Cynthia, thank you so much for the super chat. Oh, Maya, first time being on a live. You guys, if you're still here, the over 14,000 of you that are here, go ahead and pop a 1 in the chat. Because it's time. Okay, I'm going to just make a note. Balaton is a popular chocolate whiskey. All right. We're going to make it. We're going to figure it out. We're going to find it. Miguelina, will you make a note? I don't have a pen. Emily, are you prepared? No, I don't have a pen. Emily, can I convince you to refill your drink? Not tonight, unfortunately. What types of books do you read for fun? It depends. Right now, I'm in the middle of some of the MIT Essential Knowledge series, which I really like. I've also been going back through the Stoic philosophers I enjoyed in college, but I also have Hamnet. What is that called? Yes, Hamnet, that I really want to read. I also like things like Pride and Prejudice and Zombies. I also like teen lit, especially of the dystopian variety. And then there are the books that I read only on Audible. Biographies, stuff by the authors. I have cat hair all over me. Just a mess. Fred, a mess, my love. Anyway, so it just depends. It depends on my mood. It depends on, mostly mood. So, mostly mood. And then there are the Secret Sassy books. We won't even talk about the Secret Sassy book club. Look at all of you. Look at this. But this, you know what, this flight, because I'll also sometimes read on the plane, but I get motion sick. Thank you guys for everybody who's due. Ooh, that sounds delicious. We love Bailey's Irish cream. So good to see so many of you that are new here. Wonderful. Yes, we definitely have kitty glitter. It is true. What was I going to say? On the plane. This trip I was just watching movies because I was brain tired. So on the flight back to Nashville, I watched Lost City with Sandra Bullock and Channing Tatum. It was so fucking funny. I really enjoyed it. I love a good dopey romantic comedy. I love it. It was so funny. It's worth a watch. It's absolutely worth a watch. It's worth a giggle. And so then I had to double down because then the flight I had time for part of a second movie, not a full one. So I couldn't watch something I hadn't seen before for part of a second movie because then like your flight ends, but your movie's not over and you're like, fuck. So I had to pick another movie, but it was either down the Channing Tatum route or down the Sandra Bullock route because they had 21 Jump Street, but I was sitting next to my little one. So I was like, maybe not with 21 Jump Street, but I put on, they had Miss Congeniality, The Proposal, and something else by Sandra Bullock. So I'm like, okay, we're just going down the Sandra Bullock rabbit hole. So we went with The Proposal, which was hilarious, and I loved it. Let's see. Loved Lost City, clearly made for millennial women. I mean, it was really, really funny. It just had so many great moments. And I love The Proposal too. And I think they parallel pretty well. I mean, you know, Sandra Bullock needs to just lighten up a little bit because she's just a go-getter with books. It was so good. I love that. Betty White definitely steals The Proposal. It's such a fun movie. I love a silly, fun romantic comedy. I love Sandra Bullock's physical sense of comedy. I just enjoy it. Why the glass of iced whiskey? Why the glass of iced whiskey is Depp paying the ACLU? Because New York law allows for it. Jenna Benna, thought you were still out, coming in late, miss you. I mean, if I wasn't locked out of the tech screw, I would have let you know. I'm sorry. Summer Savage, Bailey Sarian, Charlotte Dobre, Brian Christopher, Technoblade. I mean, inspired by JD, my own DV story, and my father's, to write an article about the trial, the truth and justice prevailing, at Medium, profile infinity _963. Thank you for sharing the profile infinity, the healing butterfly, so people can check it out on Medium, profile infinity _963. Thank you. C minor op 67, still in shock about techno. He was so young, such a funny, quick-witted guy. His comedic timing and delivery were top notch. Donating to his cause. Absolutely. Absolutely. And to his memory, really. Creators bring us together as a fire to a home. We pray for Technoblade to have a full of light journey to a new warm home. One of you commented on the Twitter post that he was, just surrounded by all the diamond blocks. I loved the Minecraft references. So, Gen C, no apologizing for feelings, none. I'm still working through that. Monica said, I love you for letting it out, Em. It doesn't opt. It's not an opt. It doesn't opt. It forces its way out. It's so much more personal because it's so very close to home, so much to Technoblade's family. Absolutely. Well, water cheers to you, Monica. And yes, Technoblade's family just to circle back to what we talked about earlier, but just did such an incredible job honoring his community and his memory. And that would be a tremendously difficult thing to do. And it's such a beautiful thing that they did it. And that is pretty something. Question. How are you such a badass lawyer and mom? From your fave med school students. I don't know. I just don't give a fuck. And I try to be a good human and give other people grace and give myself grace when I need it. And I've started just running my own race. You've got to follow your own arrow. Look, archery, pick your metaphor that works for your life. Stay in your own lane, which I know comes from other places, but for me, it always rings of swimming, because I stayed in my lane. Like, I stayed in my lane. You stay in your own lane. And with archery, you follow your own arrow. Like, you just have to live your life and do it with integrity. And you can absolutely do that. So that, that's where it comes from. And I will fight. That's a little bit of a Taurus in me, but I will fight absolutely for what I believe in. And I encourage all of you to do the same. Red Kool-Aid in the Boston Harbor sounds like a good way to celebrate this year. I mean, I invite all healthy forms of discord and disagreement. I just don't always invite it in the chat. I said healthy, non-toxic. Maria, this is a story. I saw Dr. Spiegel last week in the flesh at my niece's white coat ceremony. Congratulations to your niece. He seemed full of himself, watching you while making carrot cake jam. Okay, that sounds delicious. We all saw the Newsweek article. We know, Dr. Spiegel. He was mad about one mean phone call. Odine Irving, cheers, Emily. Keep moving up. You're so great. Daughter is Northwestern law grad. Cheers to your daughter. Can you explain racketeering? Not a lawyer, just a nerd. Law nerd Peggy R. Using an organization for the purpose of doing illegal shit. For a more thorough definition of racketeering, CEG, my breakdown of the new lawsuit to be filed. I don't think it's been filed yet. I need to go find it. I need to go find it. I'm out of the loop on the Girardi stuff, but I covered it here when Edelson PC alleged that the Girardi Keese firm was running like a racketeering organization, and it breaks it down very well. Anna Rose said, here for your content, compassion, humor, and DMB shout outs. Enjoying the stream and getting ready for David Alpine Valley this weekend. Have the most fun. I know some people that are going to be there. Show count 66 for me and 90 for hubby. You are my people, Anna Rose. You are my people. I love that so much. Have a wonderful time. May you see the songs that fill your heart and, you know, all along the Watchtower, because Stefan is Bay and that song fills my heart. So does Two Step, by the way. I haven't gotten to see it live a lot lately. Question, some days it doesn't feel like they are people, but instead of the money. Kim, I know this was referencing something way, way earlier, and I just couldn't wrap my brain around what. Apologies. Hello from Texas. I was under the impression that in federal prison, you do not get time off for good behavior, but I might be wrong. There is a split. It's not the same as in states, but the feds is not straight day for day. Can you review Amber Heard's appeal? Andrea Burkhardt is doing it, but I trust you. Well, look at all the opinions. It's always good. More opinions are always better. She hasn't filed an appeal yet. When she does, I'll review it. What I'm not going to do is speculate on appeal. Why? Because I have so much other shit to cover. Other stuff to cover. Two Step is my all-time favorite, Dave. It's so good live. But so is All Along the Watchtower. Fall into a funny Dave story. I was at Dave in Vegas ages ago because I was still in a knee brace after my ACL repair surgery. So what, 2007-ish? Like 2007. They recorded it for one of the albums, but I was at Dave live in Vegas with my dear friend Candace, and he played Sweet Caroline. And these sweet summer children behind us were like, is this a new Dave song? And I think we actually levitated as we spun around and we're like, what? How? What? How do you not know Sweet Caroline? No idea. They had no idea. They had no idea. And we're like, bum, bum, bum. And they're like, no, none. Zero of the clues. I don't remember if we actually told them what the right answer was or just said, no, it's new. I don't remember. I don't remember at all. I just don't. Fallen Too High said it really shouldn't take this long to out predatory monsters behind bars. So frustrating. Too often they are put right back into society and prey on more victims, often with dire results. Justice is slow. Courts are slow. Getting to the right result is slow. All of it is slow. Would you ever talk about the new Emmett Till developments? I have not seen anything in court. I have seen the news reports of it. If stuff happens in court, I will look at it and go from there. But I have not seen anything happening in court. So whether something can, we will see. Thoughts on her compliments about the prison, her request to transfer countries and prison stay. I have not seen her request to transfer countries for Ghislaine Maxwell. I wouldn't be surprised. I know she has not had a good time, or she has said she has not been has not been well cared for in custody in New York, but they did put in the request for her to be housed elsewhere, and sometimes that can happen. Got a date with Joe Bob Briggs and hubby. Enjoy. Debbie Jo A, this is for all the things you teach us despite the threat of being demonetized because of the sensitive topics. Thank you. And again, this is why we do things on this channel like Patreon, like memberships here on the channel. It's part of why. So we can talk about the things that need to be talked about. And if YouTube doesn't love it, it's kind of okay. It's why I'm not hesitant to take sponsorships of companies that I like working with, because then we can just keep going and we can just do the things we want to do. That's gone. Molly Ping, just sending you love and hugs, Emily, my third try. Sorry. But you've been there for me, so want to be there for you. Though broke cancer is awful, my dad heart hugs. Molly Ping, you can always just send the comment. I appreciate the super chat. I appreciate the support. Too many. I don't think I could even get through listing those that I've lost in my life to cancer. it's too, A, I remember them all, but B, it's a long enough list that it would be very hard for me to verbally get through. And it is it's always devastating. Always. Mary Swanson said community means more today thanks to this young man. Yep, it absolutely does. World stuff aside, it's been a long week. Didn't realize how much I missed these streams. So glad to see you back, Gen Z. That's what we do as law nerds. We get together so we can be in community. That's what we do. That's what we do. That's what we do. My dad has a whole collection of Neil Diamond LPs, and they're like back now LPs. You can like actually find new record players and stuff. My kid was like, I think I might want a record player. I'm like, I'm kind of here for it. I saw a question that I really wanted to. Kathy, this is a great question. How do we know that Brian Laundrie's parents knew she was dead? We don't yet. And that is, I think, what they're hoping to get to in Discovery. We don't yet. In Discovery, they will get text messages. There's been allusions and conversations about a text confession. I don't know the date of that text message vis-a-vis the dates of these other things, but they'll be able to do that type of discovery and see if Brian Laundrie texted his parents, if there were lots of phone calls, things like that. So that's how they will start determining that. So, what's the latest on the H3 Ethan case? Love you. I have not gotten to whether or not the court has ruled on the anti-slap. We need to look back at them. So it's been a minute. I have a record player. Vinyl collecting is back up with Gen Z. Here's what I kind of like with Gen Z, liking the vinyl. It gives you get to listen to music again, start to finish, instead of kind of jumping around. So it will be it's kind of nice. There's something brilliant about going through an album start to finish, and just, there's something satisfying about the scratches and the sound of the music. That said, when I had records as a kid, Belinda Carlisle, The Go-Go's, Cyndi Lauper, Wham, and then got into tapes and then could make our own tapes, I was like, ooh. But my dad had a massive collection of records. I have to figure out where those are. I need to ask him. Wait, I'm sorry, Anna Rose, what? Met Stefan while seeing shows in Ireland at the bar at the top of the Guinness Museum. Got a photo. Hats off. That would be amazing. Stefan is back. Emily, are you fangirling? Yes. We love a bass player over here. Thanks for taking the time to break things down for those of us who are interested but don't fully understand. Faye, you're welcome. That's literally the point of my entire channel. Whole thing. Question, can the Laundries plead the fifth during deposition? They can. This is why it was so interesting during the argument on their motion, because on the motion, the attorney for the Petitos were arguing, well, what crime are you alleging occurred? The Fifth Amendment doesn't always attach. So we saw this when we talked about whether or not Duggar had the right to plead the Fifth, and whether the Fifth Amendment attached yet or not, or what have you. But if there's no criminal investigation and there's no indicia of criminal activity, the Petito's attorney is like, what Fifth Amendment right? There's no Fifth Amendment right. You're not under investigation. Brian Laundrie wasn't a fugitive on the run. There is no Fifth Amendment. So they will argue that. And if they refuse to answer things in deposition, they can make the judge make those rulings. So, and making the judge make those rulings mean at least we'll know what happened. So, yep. Will you ever cover Jasmine Harton? I have not heard of that case, Trista, but I will make a note and take a look. I have not heard of that case. So, but I've also, I just do not know. Have you ever looked into a phone number for texting? I've seen a number of content creators do this. Laura, we'll come back to this question in a week or two. There's been drama with my text line. I do have a text line. We'll get there. We'll get there. Thank you so much for the demonetized stream. I'm sure it is. Emily, I am in Nashville. Look up Game Terminal. Now y'all are gonna make me find a pen. We're making it happen. We're making it happen. That sounds fun. Wait, somebody else. Game Terminal in Nashville. Huge old school barcade. Y'all are making my day. That sounds like so much fun. Kathleen said, my favorite eldest nephew and two of his buddies have a place called Poor Decisions in Hollister, California. It's a 90s themed, family friendly tap room and arcade. That's amazing. So if you guys are in California, Poor Decisions in Hollister is where it's at. A, Kathleen, great marketing. B, I love the name. C, we love a 90s theme. All of it. That sounds amazing. Brianna said, I'm an S&E market corporate insurance adjuster. You'd be amazed at the things people don't insure that they really, really should. I'm sure I would. It just, sometimes it feels sus. So Chris CPA, thank you again for the super chat. I know we talked about that a little earlier. Question, you have to pay both state and federal taxes. Oh, Megan. So international crew, if you are in the chat or if you are in the comments section, this is the point where you can go ahead and drop a flag for where you are watching from, or where you consider home and heart. But yes, in the US, depending on what state you live in, you do have to pay both state and federal taxes, and it can get real fucking complicated. States like California, that tax burden is a bit higher. States like Tennessee, that tax burden is a whole lot lower. So you can, depending on where you live, that tax burden fluctuates by quite a bit, and it makes certain places much more expensive to live. The amount of taxes in the US, and it's funny because we talk about taxes, it's not just that they come out of everything, because yes, you pay taxes when you buy things, but then you also have to like figure them out, have people help you figure them out, and then pay them. And then if you get them wrong, you have to pay fees and fines on them for not paying them right the first time. It's so much. I think it's why Americans are so stressed out and fucked up about money, or at least one of the reasons. We're like, it's like, I don't want to get it wrong, damn it. Does Heard have to post a supersedis bond of $8.35 million to appeal, or can she just pay the $500 court cost for appeal? I think there is an appeal bond in addition to the $500 court cost, but I have not seen any solid information about how much the court bond is. So we will see how much the court bond is. I don't remember which comic we were talking about. Karen said, I would love to see you cover the Jeffrey Sedlick Kat Von D copyright infringement trial. It's been on my list. We have a whole list of tattoo copyright things that we're going to talk about, because there was an issue with the Mike Tyson tattoo being used in The Hangover 2 or 3. We have a whole tattoo copyright thing we need to talk about. So that's what we're doing. Lindsay said, Elaine got Amber Heard's name right. Snaps to Elaine. Or at least the paralegal did. But the UK court was even before her op-ed, so wouldn't it be a whole new case no matter what? Accurate. That's accurate. Sweet Pea Kate said, why would Elaine want this PowerPoint public? Any idea? Or was it the court released the PowerPoint? No, they needed to make it part of the record because they're getting ready to appeal. So it wasn't in the record. In the filing, they said the corrected transcript and the other thing weren't in the record. So they needed to find them to they needed to refile them to put them in the record. So that's why they're there. They're putting them in the record. Wonder if you could do a review on the Eric Holder defendant is Nipsey Hussle murder trial. It's been wild. Shalyn, I haven't even looked at it yet, but I can. But I have not looked at it yet. So we'll see. E-watching, what is this craziness? There was some craziness. 6 million doesn't get you a color printer or scanning, apparently. The scanning might be on the court, but the printing is... The PowerPoint's going to be special. I can't. This is D-level undergrad PowerPoint composition. Especially the non-justified center aligned. Bop it. I don't know if you want to volunteer to give Elaine a PowerPoint lesson. She should have paralegals to do that. Elaine's paralegal is actually her daughter. What? That I did not know. That would be very stressful. If this was trial by Judge A and not a jury, what do you think the outcome would have been? I don't know. Truly, I haven't really given it much thought, and I would like to give that more thought. I would like to give it more thought, but I didn't. I don't know. I think the counterclaim would have been harder for Amber Heard if this had just been by a judge. But I don't know. I think that maybe the headline, I always thought the headline was the strongest case. So I don't know. I don't know. Truly. I'm thinking about a career in law. Any advice? Do not overpay for law school so you end up $300,000 in debt. If you have an opportunity to work in law or law related or law adjacent fields, even if it's during undergrad or time before law school, absolutely try to go do that and make sure you like the day-to-day of lawyering. The day-to-day of lawyering can be a fucking grind. The money is not a reason to go into a career in law. Make sure you have a reason, like a reason you want to go into law, because there is a lot that can be done. And depending on what that reason is, there's a lot that can be done without a law degree as well. I haven't put my Nintendo Switch back from taking it on the plane. Liv is inside again. I just realized I only refer to you as call you Emily or Emily D. Baker. I can't just call you Emily Baker. This is messing with my head. No, I'm EDB. I am EDB. It's like when you call people from high school by their full name or elementary school or junior high, you just call them by their full name because that is their full name. I am EDB. Yep. Or Emily D. Baker. Emily Baker is also weird, which is why I said give Evan C. Borges his full title, because in all the other legal filings, he's Evan C. Borges. And because I am a middle initial person, I understand the middle initialing. Incredibly Average and Jax broke down exactly what happened on the actual hoax on May 21st, 2016 on Movies, Monsters, or Movies, Myths, and Monsters. New info was released. Okay. DeJuan Ferguson trial, defendant equals Elaine something great. Judge Penny specified that the bond for appeal was the full amount plus 6%. And unsealing everything. I need to go look at the reports. Lori, Leanne, that is very helpful. The bond could be the full amount plus 6%. It very much could. I am behind. What if the Geno identifies as creme brulee? Here's the thing. In the movie quote, it is, but creme brulee can never be Jell-O. It's got a crispy top. If JD pursues appealing the one count Amber Heard won, will that send a negative precedent for the Petito case since the judge referenced it specifically? No. The judge referenced it in conversation with the lawyer. The judge didn't reference it as legal precedent. The judge didn't rely on it as legal precedent. It's not even in a controlling jurisdiction. The judge was talking about it. So no, I don't. And JD has to do what JD has to do. This is a very fair point. It's July 1st. It's not thunder. On July 1st, it's never thunder. It probably is fireworks. We haven't bought ours yet because we were out of town. Will you be covering the Michigan case involving the parents and son? I have not caught up on it yet. I don't know. Eleanor said, when I got divorced, I scanned and organized my own stuff. I wasn't paying for that nonsense. It's very fair. And it is a good way to save on legal fees and probably be more organized. Amber Heard was removed from the UN page as an ambassador. We'll see what the ACLU does. Did you see that you were lumped in with Tug's co-conspirator and a fellow red-pilled incel? I didn't. Plastic noise experience. But again, I've been running around in a river for a few days. So I have not been on the Twitters much. And actually, it's been quite nice. I love connecting with y'all on Twitter. It's all the stuff outside of our little bubble of law nerds that I don't love. But no, I didn't. Tug's co-conspirator. Truthfully, before this case started, I was not familiar with Tug at all. Let's see. Brianna, the only law tuber I saw who said the motion to dismiss would fail was Peter Targos. He said it would either be denied or the complaint would be rejected with leave to amend. He doesn't think it would survive discovery, though. When I first went through the motion to dismiss, I said that it could be granted with leave to amend. That's what I thought. So, and I could see that. But Targos is the attorney in Florida who knows these judges and jurisdictions. So, I appreciate his perspective, and he was absolutely right on. Is Emily getting tipsy? Is anyone offended by that? No. Hopefully nobody's offended by that. You don't have to get tipsy when I get tipsy. It has been reported that Australia is looking into perjury charges against Amber Heard, and Adam Waldman is in Australia at the moment. Coincidence? Maybe not. And I've seen that reported as well. Can't the Laundries plead the fifth? on any or every question during deposition. We already answered that. Does Florida's sunshine law apply to civil law or only criminal law? I have no idea. We have seen quite a lot of this filed, and I think some things can be under seal, but I don't know if everything will be, but that is a good question for a lawyer. Can they charge them in civil court for murder? The Laundries, this is a way more complicated question. Yes, there can be civil causes of action for wrongful death. No, the Laundries can't be civilly sued for wrongful death because there is no evidence that the Laundries participated in a way that would allow them to be sued for wrongful death, because Brian Laundrie, by all the evidence we have, it seems that Brian Laundrie was the one who killed Gabby Petito, not his parents. I think they were probably in Florida when that happened, and they were not in Yellowstone. Did you see that you've been included in Boozy's, anonymous Reddit users' study of YouTube channels that are part of a coordinated attack on Amber Heard? It's as dumb as a box of hair. I have not seen that. Again, in my time off, included Reddit as well, and a study of YouTube channels that are part. There's no coordinated attack. I can't say that. I'm not part of a coordinated. Emily, can you make broad sweeping statements about everyone on the internet? No, I am not part of attacking anyone, and I don't think our content attacks anyone. We attack the facts and occasionally make fun of lawyers doing stupid shit because... Aaron, will you cover the Ezra Miller case when it becomes a case? I covered a little bit of the reports because they were so disturbing and there were so many coming out. But yes, if it does, which I think it will, and the reason I covered it is because there were already the protective orders issued. But yes, I am definitely keeping an eye on the Ezra Miller case. The Hollywood stuff is wild. Any movement on the H3 case? As CEG, my previous statement, I have not looked. I am looking for Tuesday to see. Let's see. It's all about money for college sports, and all sports go to the same grouping. So UCLA and USC will be Big Ten Midwest for all sports. Okay. Well, that's interesting. That's very interesting. There's a chocolate whiskey from the Seattle area. I've tried to send it to you, but shipping alcohol to Tennessee is impossible. Oh, that might be true. That might be true. Oh, that might be true. Is there any laws regarding Lifetime making the movie The Gabby Petito Story? Morally, it's gross and vile. Is it legal for them to make a movie without consent? Is it a violation of victims' rights? I'm the Mary. You're the Rhoda. You know how much I love your screen name. Good to see you. Unfortunately, victims' rights go state by state, and the victims' rights protections are minimal and normally apply to what's going on in court process and not to their story. Could their families try to shut down the use of their name and likeness? Possibly, but is there a fair use newsworthiness to reporting? Possibly, but a Lifetime movie, I don't know if would fall under that. So could there be issues? Yes. But victims' rights would have to look, I would think, first in the intellectual property world of name and likeness, saying you can't use name and likeness to sell a movie. So we'll see what her family does. I didn't realize they were trying to make a Lifetime movie out of it. I heard earlier today that federal prison does not give time off for good behavior. Am I wrong? They have a day-for-day calculation that is different than state. So it's not, they don't get a direct, you serve one day and you get one day. They do have an apportionment. What federal prison calls their apportionment, I do not remember. So sent a Twitter DM about chocolate whiskey from Whiskey Smith. I will look at that for sure. I heard your TED Talk the other day. Just thank you. You're welcome, Kelly. So I have to look at the federal apportionment. Are you a fan of the Vampire Diaries and spinoffs, the originals or the legacies? I have not watched the spinoffs. I watched some of the originals. I do like the Vampire Diaries. It's been a long time. I want to go back and watch Buffy the Vampire Slayer. Saw some reports today about Amber Heard hanging out with an executive director of the ACLU in the Hamptons, and that the ACLU removed her from their website. Accurate? I have no idea. I have no idea. Irish Aiden said, thank you for always being you, authentic and joyful to watch and be around. Thank you. Also, shout out to the mods killing it. Our mod squad is fantastic, keeping this chat a nice place to be and making sure that we are not, diagnosing and name calling, even when we don't like people. It's hard. It's hard. Covering the laundries is hard. Covering yeeted spears is hard. It's hard. But we can do it. We can do hard things. LeVar Bell actually originally coined the term stay in your lane. His influence on common English phrases is not talked about enough. Thank you, Vamp, for that. I always appreciate learning something new. Happy 4th of July weekend, Emily in chat. Thank you. Sweet Caroline PSU. Yeah. Can you cover? I have looked at the Young Thug stuff with the RICO charges. But I think I will be. I realize RICO is difficult to understand, but yeah, I really enjoy covering white collar crime. It's always very interesting. Thank you, Lauviv from Cardiff in South Wales, UK. I have purple hair like you. We love the purple. It's fun. Hugs for your sorrow at the loss of Technoblade. I'm running behind in the live, so just hearing it now. I am, and it's a loss of a person, a loss to a community. It is. A friend of mine, Depp situation with his wife, 2 kids. She picks fights, hits him when he tries to leave. He decided he's done. Best way he can proceed. Vanessa, with support and legal counsel in your area, particularly legal counsel that is versed in working with men in child custody in that jurisdiction. So, T in Tennessee, sorry, signed in late. Don't apologize for me. Is Amber Heard ever going to stop? Unlikely. Well, no, probably not. Do you think she will ever be held accountable by Australia? I don't know. Fellow Nashvilleian here. Yay. If you haven't been to Loveless Cafe, check it out. I will add it to the list. Always like finding new places. There's so many new places to find. Vanessa, it's okay to say thank you. It's okay. It is okay. Question. Need to satisfy ex-wife. Me born in 74. Her born in 77. Both South Bay, LA, but mobile. She swears she's met you. Thoughts? We're the same age. So probably. I'm South Bay, Doc McFuzzball. So I'm South Bay. She and I are the same. I mean, I was born in 78, but she and I are the same age. So depending on how and when she was in the South Bay, yes, I spent most of my life in the South Bay, went to high school in the South Bay. Most. Why can't a jury question a witness by submitting a written question through the judge? Karen, it depends on the jurisdiction, but the questioning generally has to be done by the lawyers because sometimes the jury will ask questions that legally cannot be asked. So some jurisdictions allow it, some jurisdictions allow it with things that are investigative bodies like grand juries, because those are investigative bodies, but it really depends. But how would you feel if you're a juror and you wrote a note and it was like, we can't answer that? You'd be like, what the fuck, man? But sometimes the rules of evidence don't allow for answering all questions. On a more positive note, I quit my job at the California DMV headquarters today after 12 years of torture, thinking of grad school, maybe law. I like research. Milo's mom, there's lots of research to do, and there are lots of law jobs with research. If you like research, the law has lots for you to do. Thoughts on the Bull series finale? I didn't watch Bull. I'm sorry, Callum. I don't have thoughts. I don't remember what was going on in life. There was a very busy period of DA young childrenness where I did not watch TV at all. Less the odd reality TV show that's easy to jump in and out of. But there was definitely a big chunk where I was just working all the time. Thank you so much for the super chat question. Sorry if it's been answered. Have you seen a Fort hearing in Australia for perjury against Amber? I have not seen that there's going to be a hearing. I have seen reports. Question, when are you covering the Vince McMahon stuff? The Mad Titan, hopefully soon. It is on my, the list of intended things that I want to cover is soon. So, soon. So yeah, the chat can answer what their thoughts were. Question, have you seen Real Housewives of Beverly Hills? Lisa Rinna deleted Instagram throwing shade at Real Housewives of Dubai. I did because I watch a lot, or I follow a lot of housewives related accounts on Instagram, and they all put it up there. It's just, whoo, it's just a whole thing. Elaine made Tug a lot more famous. I didn't know who he was, and YouTube recommended him to me during the trial. And again, Tug's been covering this case. When I went back and looked, Tug's been covering this for years and years and years. I cover a lot of cases. I popped in and covered the UK ruling. People are like, but there's so much more. I'm like, I'm sure there is, but this is what the judge ruled. And the appeals were denied. And this is where we're at. And when it comes back to trial in the US, I'll cover it. And that is what I did. So I did not go looking for all the outside information, because I really did want to look at what was happening in court without being like, but I know this and I know this. Sometimes in the case, it's unavoidable because I already know things. Like when it comes to the Toddy Westbrook stuff and they're pulling up Dramageddon 1, 2, Carmageddon and all, I'm like, I watched it all go down because I love YouTube and I love the platform of YouTube and I watched it. So that I had outside knowledge of because I watched it all happen. If there's a case going on that I'm watching and then there's shit popping off on social media, I will pay attention to that. A lot of that stuff gets deleted and I will pay attention to that in real time. Like we're covering Erika Girardi and then she's doing stuff on social media that might relate to the case, might be talking about the case. I'm going to pay attention to what's going on social media. When she's going back and forth with an attorney commentator on the case, I'm going to pay attention to that. But I generally don't do investigative research on the cases I'm covering. And if I ever do that, I will tell you I'm going down a rabbit hole. I want to know more. Normally the rabbit hole I go down is like, oh, there must be other legal cases. Let's go look at what the other legal cases are. Just because I don't have time, truly, and I want to keep covering the things we're doing. And the thing with court cases is they just keep moving, and we get so much information in the court documents that's really what I want to stick to, is what's going on in the court cases. So yeah, that when they're throwing out Emily in the court filings, she knows that's true. My lights all just went out. Oh, I bet they're still on a timer. That's fuckery for the lights. The lights are like, girl, go to bed. Oh my God, because we've been on for 3.5 hours. True, girl, go to bed. True, girl, go to bed. Oh man. So with that, yes, I definitely noticed when I am mentioned in the court filings. So that is for sure. So the lights were like, you're done. Holy moly, 3 hours, 3.5. Joining from third shift at Walmart, Carrie, thank you for what you do. I'm sorry that we're wrapping up, but there's plenty to go back and look at. Can we not nod the Diana's shade? I don't. I might be reading it wrong because, it's time for me to go to bed. It's late. So a little behind here, but you can ship alcohol to Tennessee. I live in Tennessee and have alcohol sent to me a few times. You might have to have it sent though from someone who has a license to send it. Possibly. So Emily, can I get an early birthday shout out? It's on July 5th. Happy early birthday on July 5th. Happy early birthday. KVB Studios. This is going to be, that was going to be my last question. Where'd it go? Darn it. Wait, things moved. Are you going to cover the Britney? I think it's Griner. I think that's how I pronounce her last name, situation in Russia. I don't know about the rumors. I have seen reports that she was in court either yesterday or today. I will be looking at it. I have no familiarity with Russia's system of justice. So really, it would just be me covering the reports that are coming out of what's going on in Russia, because I have no experience there at all. But I am following along with it and with the news reporting of it. Celeste Crawford, this is not dumb. What is pop culture? I don't know. Do we have a good working definition of pop culture? Hold on. Let me see what dictionary.com says is the definition of pop culture, because I can give you how I define pop culture. but I'm sure there's an actual definition. Cultural activities or commercial products reflecting, suited to, or aimed at the taste of the general masses of people. Basic shit. That's what dictionary.com says. I don't like that one at all. Let's go to Urban Dictionary. Don't go down a rabbit hole on Urban Dictionary on your work computer. Learned that the hard way. Though it did give us quite a laugh. But at the DA's office, we always had to Google weird shit. Pop culture is short for popular culture, describes the lifestyles and taste of the majority of mostly younger people. Music by people like Britney Spears and Hilary Duff are examples of pop culture, as is emo and prep. Pop culture changes with the youth of the world. Lindsay Lohan is part of pop culture, and so were the Beatles, swing, and opera back in the day. So those are kind of cultural phenomenon. So I see pop culture as, for me, things relating to celebrity, things relating to the internet, things relating to social media, things relating to things that are truly, really popular, which sometimes it, shifts between things that are newsworthy. I think the Gabby Petito case and the Depp Heard case, though very different, show that even if it's not, celebrity, things can be all consuming of what everyone's paying attention to in the moment. And so I think a lot of people that don't normally cover pop or follow pop culture follow Depp versus Heard because it was everywhere. And I think the same with Gabby Petito's disappearance and murder. It was, you could not get away from the relevant topic. It was what everyone was talking about and kind of was thinking about and having conversations about all at once. So I think that is kind of my best definition of how I see pop culture, but it is kind of the popular topics around, for me, the internet, celebrity, musicians, that kind of stuff. So question, have you seen Erin Brockovich case at Beverly Hills High School? No, I have not. I've not. I've been to Beverly Hills High School numerous times. Is it about the sliding floor over the pool? I'll take a look. I will take a look at the Beverly Hills High School case. Very, very interested in that. So that's kind of, thank you, chat, for also how we're talking about popular culture, but that's how I see it. I really do stick to things that are related more to pop culture, where some legal commentators really want to cover what's more traditionally seen as hard news, things like the Supreme Court, things like school shootings and stuff like that. Sometimes the hard news is hard. And sometimes we just need to learn the law through the things we love to talk about. And pop culture is one of the things we love to talk about. And I think we get a really good understanding of the law when we break it down around topics that aren't so polarized, because we can learn to have differences of opinions and conversations and compassionate conversations around things that aren't so deeply polarizing. And that's really, really important to me and to all of you, because our brains learn better when we are not in fight or flight. And a lot of the traditional news causes that fight or flight response. And especially for me, my content really started to shift during 2020 because I didn't want to talk about the panini anymore. And it was so stressful, and it was all encompassing, and it was everywhere. And this community was an escape for us to talk about other shit that was going on. And this community remains an escape for us to talk about other shit that's going on. It's still important. It's still shit we're interested in, but it's not as all encompassing and not as difficult as some of those things. So I didn't know about the Beverly Hills cancer rates. I'll absolutely look at that, though. Absolutely will look at that. That's an odd thing. Pop culture, it's my life. Yep, mine too. And I love it. I really do. I enjoy reality TV. I enjoy watching what's going on social media. I enjoy, if YouTubers are suing YouTubers, I want to talk about that too. So, all right. There was one other question I saw. I can't pull it. Here it is. Carrie whispers, will you go over the Ghislaine Maxwell trial? I have a lot of Ghislaine Maxwell coverage on the channel, you're going to have to search it by last name, search it by Maxwell, and you should be able to find it. It doesn't always get recommended by YouTube. Why? All of it's demonetized. All of it's demonetized. So, Emily, your Nick Schneider is showing, yeah, well, there's certain words that my video will never get seen by anybody. I don't mind talking about all the things, but the 2020 panini, a lot on YouTube started referring to it as the 2020 panini, because you can't say the other word that starts with a P. It's a parsnip. If I started saying the 2020 parlay, we would all think I was talking about the trial. All right. With all of that, it is so the mods are like, welcome back. We had a lot to cover. It's so much. Thank you all for being here. Thank you for being law nerds. I'm going to have to change may your gas not be $7 a gallon, because fucking hell, being in California, their gas was well above. There was gas well above $7 a gallon. What the fuck? Well above. Like here Middle Tennessee, I'm looking at gas upwards of $5 going, damn. When we moved here, gas was $2. Like, it's a lot. Upwards of $7. Y'all stay safe. I know it hits. I know how badly it hits, especially when in so many places in California, there's no option but to drive everywhere. And it hits. It was wild. The amount we spent on gas in our rental car was wild. Upwards of $7. Never in my life seen it. Never, ever, ever. All right, y'all. Thank you for being here. Thank you for being law nerds. Thank you for noticing we did a little bit of a rearrange today when I was procrastinating. I was actively procrastinating by kind of moving things around. Those of you that follow me on the Instagram would have seen it. All right. With that, it is time for me to go. Stay safe. Take care of yourselves. Take care of each other. I will be back after the 4th of July weekend on Tuesday. We have lots more topics to cover. I will be around the social medias till then, and I will see you in the next one. Bye.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.